bench, and the society. My name is Shola Sheyele. I'm a lawyer and journalist with Channels Television. And this is my second time of moderating this business luncheon, so it's a privilege to be here. And I thank the partners for inviting me again. And I want to warmly welcome everyone. So please give yourselves a round of applause. I know you could have been somewhere else, but we're glad that you're here to talk on such an important issue today. Let's start by doing things the proper way and committing this event to God. So we'll start with the opening prayers. Can I have Mr. Emmanuel Bassi to lead us in the opening prayers? Mr. Bassi. Okay. So before the prayers, we take the national anthem. Okay, great. Please let's rise for the national anthem. Sit down.
Shall we bow our heads in prayers? Heavenly Father, we thank you for today. We thank you for the opportunity that you have given to us to be gathered here together as stakeholders in the Nigerian justice system to discuss and provide solutions to the issues that affect the justice system in Nigeria. We pray, Almighty Father, that you shall give us the wisdom to be able to articulate and provide practical solutions that shall be implemented to make the Nigerian legal system and the justice system itself one that we all shall be proud of. In Jesus' mighty name we pray.
Good day, everyone. Let's pray. In the name of Allah, the most gracious, the most merciful, we thank Almighty Allah for granting us the ability to be here today to witness this program. And we pray that the knowledge being shared at this venue should be well implemented in our justice system. We pray that we're able to gain more knowledge and be able to implement it well. Amen.
And straight away with the PA Ajibade and Co. to give us some background info. Where's Dr. Miami? To shed more light on why this topic and why we are here. Thank you, Dr. Miami.
Thank you very much. I adopt the existing protocols established by my good friend Shola. Distinguished ladies and gentlemen, good morning to you. On behalf of the management and staff of the law firm of SP Ajibade and Co., I humbly welcome you to the 18th edition of the annual business luncheon. And this year's theme is rebuilding public trust in the Nigerian justice system. Historically, the annual business luncheon is our flagship CSR initiative and is a platform specifically designed to spotlight contemporary issues that impact upon the legal profession in particular. So the aim is to bring together thought leaders, professionals, to discuss, not only discuss, provide practical solutions to these problems. So for instance, the maiden edition in 2008 focused on globalization and the challenges of practicing law as a business. Way back in 2008, that was when there was a shift in thinking that law is a vocation, vis-a-vis that law is both a vocation as well as a business. Otherwise, you won't be able to practice law. That was way back 2008. And since then, we've engaged several contemporary topics. I mean, for example, in 2011, the theme was the future of legal practice in Nigeria, developing and deepening partnerships, because we believe that partnership is the way to go. And since then, we've had several. I remember about 3 years ago when the Japa syndrome hit the legal practice and most law firms were losing associates. The theme for that year was talent retention, challenges, and the future of legal practice in Nigeria. If all the associates are gone, who will be the next crop of judges? Who will be the next crop of lawyers? Who will be the next crop of senior counsels? I mean, we've had several. Last year focused on the electoral problems within the NBA. That is a topical issue. Practically every NBA election, the last 2 or 3 now, has been fostered with all sorts of allegations. So this year we're here to discuss and to provide solutions on the issues of rebuilding public trust in the Nigerian justice system. The Nigerian justice system has a lot of problems, quite all right. We have the problems of improperly trained lawyers. Yes, that's part of it, but that's not the root problem. We have problem of a few corrupt judges. We can't run away from that. But that's not the major issue. We have problems of contradictory judgments of courts. We have problems of laws that are difficult to enforce. But by far, the most fundamental problem we are grappling with in this profession in 2025 is the problem of the erosion of public trust. Many citizens, truth must be told, many citizens believe that the justice system is broken or that justice is only available to the highest bidder. That's a matter of perception. It may not be true. The learned Silk J.S. Okutepas, in an article that will be referenced much later, made a startling statement. He said, lawyers are now the protectors and enablers of evil. That's a profound statement. But again, it's a matter of perception. The days when they said the courts or justice system is the last hope of the common man I use the word seems to be something that is slipping away from us. And that's why Lord Denin said, justice must be rooted in confidence. And that's where the issue lies. Public trust is confidence of the public. So our speakers for today will be dealing with these issues. How can we rebuild public trust in the justice system? Can the average citizen say, yes, I believe that the court will do me well. I believe that the court will set right the wrong against me. Or does the public have this perception that, oh, well, we'll go there, spend 20 years, and at the end of the day, I will come back home empty-handed? This question of what the public feels about our justice delivery system is what we are here to address today. Questions like, how can we what is the real problem? How can we ensure that this problem is solved? Ethics, discipline, transparency, all these questions will be addressed today. So once again, I welcome you. You are in for a treat. Welcome once again. Thank you.
Thank you, Dr. Kola Mayomi. How can we rebuild public trust in the justice system? And we've heard of Jankara judgments, we've heard of supermarket judgments, we've heard of cash and carry judgments and orders. I mean, these are some of the statements that have even come from some lawyers in some cases and some members of the public. We have heard of justice for sale, justice to the highest bidder. And I believe that our panelists and our keynote speakers have been carefully chosen to address this very important issue of how we can rebuild public trust in the justice system. But now we're going to listen to the Attorney General of the Federation, who is joining us virtually, Prince Lateef Fagbemi, Senior Advocate of Nigeria. Please, can we take the Attorney General's remarks now?
Thank you very much. First, I apologize for my inability to be physically present. I left Abuja this morning, just as we were about landing in Lagos. The pilot came on the air to say that the weather had turned from bad to worse. So that made it a bit impossible for us to land. We had to come back to Abuja. So I apologize. But I am also happy that this platform is available for me to say a word or two. I recognize the presence of all the dignitaries, particularly the former #2 in Nigeria, commitment year after year by Dr. Babatunde Ajibade, Senior Advocate of Nigeria, and the partners of the firm. Their work has provided a forum where the bar and the bench pause to reflect on the direction of our profession and the justice system. Since 2008, this luncheon has examined issues that shape the legal practice and the administration of justice. Each edition has addressed a concern of its time: the pressures of globalization on legal practice, the demands it places on legal education, and the challenges of practicing law as a business. It has engaged on ethics and integrity, on how lawyers can deepen partnerships, and on the relationship between the courts and the law enforcement agencies in civil disputes. In recent years, the luncheon has turned its attention to the regulation of legal practice, the future of lawyering in a technology-driven world, talent retention, data protection, the need or otherwise for a scale of charges for legal services, and transparent elections within the profession. These topics reflect the needs of our profession and the quality of this platform as a space for conversation. This year's theme, Rebuilding Public Trust in the Nigerian Justice System, Responsibilities of the Bar, the Bench, and the Society, continues that tradition. Public trust in the justice system is central to the existence of the legal profession. Without trust, the system cannot function. Without trust, the public cannot rely on the courts for the protection of rights or the resolution of disputes. Without trust, the work we do loses meaning. Distinguished ladies and gentlemen, the Nigerian justice system faces pressures. Some are structural, some stem from gaps in process, capacity, and funding. Others are rooted in the behavior of individuals across the bar, the bench, and the wider society. Yet, in all this, one fact remains: trust is built through conduct. Trust is maintained through fairness, efficiency, and transparency. Trust is repaired through action. Across the sector, we are seeing steps aimed at strengthening that trust. Under the leadership of His Excellency President Bola Ahmed Tinubu, GCFR, the federal government has prioritized the strengthening of the justice sector as part of the renewed hope agenda. The rule of law and institutional reform are central to this administration's vision for national development. The federal government sponsored the Judicial Office Holder Salaries and Allowances Bill to the National Assembly, which was passed into law to review the remuneration of judicial officers. This was necessary. Adequate remuneration is one safeguard against compromise and a recognition of the weight of responsibility of judicial officers, judicial officers bear. It also signals that the government understands that an independent and effective judiciary requires investment. The Federal Ministry of Justice has developed and launched the National Policy on Justice, a framework addressing 20 thematic areas, including access to justice, fair and speedy dispensation of justice, transparency and accountability, alternative dispute resolution, independence of the judiciary, and application of technology in justice administration. The ministry also launched the plea bargain guidelines to bring structured transparency and consistency to plea bargain processes in criminal prosecutions. Under this administration, the Arbitration and Mediation Act was passed to strengthen Nigeria's framework for alternative dispute resolution, positioning Nigeria as a competitive destination for commercial dispute resolution. The administration has prioritized the reform of correctional services and the discongestion of custodial centers through alternative dispute resolution mechanisms and the review of cases involving awaiting trial persons. In partnership with the judiciary, the executive has worked to support the deployment of technology in court processes, including the administration of criminal justice monitoring portal at the federal level. When implemented, the portal will allow stakeholders to track arrest, detention, and movement of cases through the criminal process from the point of arrest. Some states are now exploring similar portals, drawing from the federal model. The Honorable the Chief Justice of Nigeria and heads of court have also taken measures to improve justice delivery and public confidence. One example is the public announcement of proposed judicial appointees and the invitation for public comments on their suitability. This represents a shift towards transparency in appointment. Another example is the ongoing digitization of court processes by various courts, including the Borno State High Court, Rivers State High Court, and the Federal High Court, among others. These efforts sit within a larger context. It was with awareness of the sector's challenges that we convened the National Summit on Justice 2024. The summit brought stakeholders together to examine the justice system and agree on reforms. The communique signed by the Honorable the Chief Justice of Nigeria, the President of Nigerian Bar Association, and me has been shared with all attendees by the organizers. The recommendations are clear and actionable, and steps are being taken towards their implementation. Before I turn to today's program, I must address the survey conducted by SPA Ajibade and Co. ahead of this event. The decision to ground this discussion in data is commendable. Too often, we rely on impressions and anecdotes when we speak about public trust. This survey offers some more rigorous and Mr. Akim Bello Osagi, reflecting a combination of voices from the executive, judiciary, the bar, the business community, and the civil society, is assured that today's discussion will reflect the full range of perspectives necessary for addressing public trust. I thank Professor Yemi Ajibade, SANGCON, and each of the panelists for agreeing to speak on this issue. Your presence here today reflects a shared commitment to the restoration of public confidence in our judicial system. We are fortunate to have your voices at this table and we look forward to your contributions. As we discuss today's theme, the focus must remain on responsibility. The bar has a duty to uphold ethics and professional conduct. The bench must reinforce fairness, openness, and case management. Society must also play its part by engaging constructively with the system and supporting the rule of law. I commend SPA Ajibade and Co. for sustaining this platform. I acknowledge the contribution of Dr. Ajibade SAN, Babatunde Ajibade SAN, whose work has supported legal development, professional dialogue, and justice sector reform over the years. I look forward to the discussions ahead. I want to thank you most sincerely for giving me this platform, and I wish you very successful deliberations. Thank you.
Thank you, Honorable AGF. Without trust, the work that we do loses meaning, and that's one of the things that the AGF captured. We also thank the AGF for some of the reforms that he has spoken to and the commitment, the recommitment to working on those reforms. The AGF also talked extensively about the survey that the law firm of SPA Ajibade has conducted, and we'll get to that survey shortly. Thank you again, Honorable AGF. Please let's give him another round of applause. It's time to listen to our keynote speaker, and our keynote speaker really needs no introduction. The former Vice President of Nigeria, I remember that I encountered him as a law professor at the University of Lagos, and he was always willing to take my questions and educate the public on some of the reforms and some of the issues that we needed to address at that time. And it's good to see that he has kept up, in that light. Let's make welcome our keynote speaker, Professor Yemi Osinbajo, Senior Advocate of Nigeria, GCON. Thank you, Prof.
Thank you very much. Please sit. The Honorable Justice Habib Adewale Abiru, Justice of the Supreme Court, the Honorable Justice Adefokwe, the Honorable Justice Oladotun Adefokwe Okoje, Justice of the Court of Appeal, retired, Professor Pat Utomi, Mr. Olumide Akpata, former President of the NBA, Mr. Charles Adeogun Phillips, Senior Advocate of Nigeria, Dr. Babatunde Ajibade, our host, Senior Advocate of Nigeria, Senior Advocates of Nigeria present, members of the bar, distinguished guests, ladies and gentlemen. Let me begin by thanking the law firm of SPA Ajibade and Co. for providing this very important platform to continue the conversation on rebuilding public trust in the Nigerian justice system. And I must say that Tunde Ajibade, SEN, has been one of the most consistent advocates for judicial reform that I have yet seen, and I mean that quite seriously. I was looking at emails that he sent to me in 2015, 2017, and 2016, 2015, 2016, 2017 on the matters of judicial reform. And in 2022, he signed the communique of the Justice Sector Summit held by the NBA at the time in collaboration with the NJC. And of course, he was involved in our 2020 webinar. That was the one conducted by the Justice Research Institute. And then, of course, the 2024, the new proposals. I mean, something has to happen. If anyone is this dedicated, something really has to change. The theme speaks directly, I think, to the urgent need for a comprehensive overhaul of our administration of justice system. Many of us are already familiar with the deep-seated failings of our justice system. And the survey, part of the survey which I'm told we'll be looking at, already tells us, that's the SPA Ajibade survey, already tells us that at least 73% of practicing lawyers who were surveyed believe that public trust in our system of justice is poor. So, I mean, if 73% of lawyers believe that public trust is low, that really, I think describes the nature of the problem. I'm not going to dwell on many of these problems, except where necessary, to illuminate the reforms that are being proposed. And my focus is really to outline some of the necessary reforms and examine the proposals, especially those contained in the revised national policy on justice 2024 to 2028. That's the one that the Federal Attorney General referred to a moment ago. But before I do that, let's just set out some foundational parameters. Reform itself, we know, is urgent because public confidence in the fairness, in the relevance and credibility of our justice system is being eroded practically every day. But the nature and scope of any reform agenda must be shaped by the nature of the failings that we seek to correct. And these failings flow from philosophical, structural, and institutional deficiencies. While we will examine the structural and institutional issues in some depth, the philosophical issues are also important, and they are foundational. A justice system must align with the common notions of fairness and justice. Judicial reasoning, in particular, must reflect both the letter and spirit of the law. Otherwise, outcomes become technistic abstractions that are completely divorced from common sense. The public expects principles that promote substance over form. We lawyers talk about substance over form, but the public, that's what the public expects, not rigid adherence to some procedural technicalities at the expense of substantive justice. The second philosophical principle is that the justice system is a public trust. It is a public resource funded by the people. It is paid for by the people and is entrusted with the protection of rights, the resolution of disputes, and the preservation of democracy and the rule of law. It does not belong to judges or lawyers alone. And it's a very important point to repeat, that the justice system does not belong to judges or to lawyers alone. It actually belongs to the society that it serves. And this is why the governance structures of our justice system must be plural and representative. They must represent the bar, the bench, the society, civil society, every aspect of society. As being an affront on the judicial dignity, but rather should be recognized as an expression of the accountability that is owed to the public. Very frequently, and Tunde and I were talking about this just before we came here, very frequently, when there's a criticism of the judiciary, judges tend to feel that this is a criticism of themselves. But this resource, this thing called the justice system, does not belong to judges. Oh, no, it doesn't. It belongs to all of us. It is so important and so fundamental to our lives that we all must be concerned about it. And we all rely on this system. When it does not when it lacks credibility or effectiveness, we all bear the cost. So my reflection today will be guided largely, as I've said, by the publicly available revised national policy on justice 2024 to 2028. And this was validated at the National Summit, again, to which the Federal Attorney General referred to in April 2024. And also by some of the practical lessons from our justice sector reforms in Lagos State between 1999 and 2007. Now, there are at least two reasons why I think the proposals, this 2024 proposals in the revised national policy on justice are important. At least two reasons. The first is that these proposals were initiated by the Federal Attorney General. Now, that is very important because, in my view, this is how to do justice sector reform in Nigeria. The executive must take the lead. And it may sound strange, but that is the way it works. The executive must be prepared to take the lead. The second is that the policy and proposals, all these policies, the 2024 policies and proposals, were a product of the engagement of the executive, judiciary, and the legislature, and law enforcement, as well as civil society. That multi-stakeholder approach is also the right model for national reform. There has to be a multi-stakeholder approach. But the conversation between the executive and the judiciary is crucial. The conversation, a sit-down between the executive and the judiciary is crucial for any reform that will be successful. In initiating our reforms in Lagos State, the 1999 to 2007 reforms, a clear blueprint was drawn up by the Justice Policy Committee. It spends another 3 years and 4 months in the Court of Appeal. If it goes to the Supreme Court, it takes another 6 years and 6 months to conclude. Now, altogether, a commercial dispute can take nearly 13 years from first filing to Supreme Court judgment. Now, these are averages. Many cases take even longer. I'm sure that almost every one of us that's seated here who practices in our courts would have a case that has gone on for much longer than 13 years, especially if the case goes to the Supreme Court. I've had an appeal, for instance, pending since 2014, which is still seeking a date at the Supreme Court. Now, such delays are especially disastrous for business and investment. So to deal with delays, a multi-pronged approach should be adopted. And this is also the approach adopted in the 2024 proposals. First is technology and digitization. And I think we need to be deliberate about technology reform. And today, there are several complementary strategies. There's so many different things that we can do with technology. It's far easier than the days when we were speaking about technology in 2000, 2001. We need expanded digital systems now, such as e-filing. Some courts are even using e-filing, the digital filing of cases, online submission of pleadings, digitized record keeping, reducing reliance on physical paperwork and the delays that arise from it. We can now use electronic processes to achieve real-time service, tracking of summonses, notices, and case status. And this will reduce procedural bottlenecks and also help us to avoid unnecessary adjournments. Today, electronic service of notices is easy to do. Service of notices even by telephone, by WhatsApp, and all that. In many jurisdictions today, including many African jurisdictions, aside from the initiating processes, personal service is no longer required. So, service by all sorts of other means are permitted. And I think we should move on very quickly to this sort of regime. We must use virtual hearings more. Very fortunately, during COVID, we were able to start virtual hearings more effectively. The Supreme Court itself was very willing to go ahead with that. And there's a proposal which I strongly support, that we should validate virtual hearings constitutionally by defining public hearing to include virtual hearings, so that, when you say a hearing is public, it also includes a virtual hearing. And also a federal policy paper to standardize virtual hearing practices in courts across the country, so that we're all singing, as it were, from the same hymn book. And this would make virtual hearings indisputably a part of our public justice system and remove some of the jurisdictional ambiguity which we experience at the moment. The creation of verbatim records is also much easier than ever before with the new AI tools that are now available. Every one of us is probably familiar with the AI tools that help us to record whole meetings. You can record your meetings, it will edit the meetings, give us minutes. I've been shown, for instance, a model of an AI tool that can take proceedings from beginning to the end, do the analysis that a judge would do, write the judgment, and give you options. So very, very soon, we're going to have AI-written judgments. I don't know what my lords are going to do about that. But I've seen a model that actually works. So I think that these things are going to radically change a lot of what we're seeing today. So it's possible now, litigants would have access to verbatim records of proceedings. And there's a proposal that litigants should be permitted to make their own audio recordings to generate transcripts subject to court certification. Access to verbatim records is essential to guaranteeing the constitutional right to a fair hearing and to improving the accuracy of our records of appeal and all that. Also, pre-action notices contribute to a lot of the delays. And the proposal to eliminate mandatory pre-action notices, especially where urgent relief is sought, is a good one. And I think it will remove a common procedural barrier to timely interim reliefs. Also, to eliminate jurisdictional gamesmanship, the proposal to put constitutional provisions permitting transfer of cases between courts, superior courts of coordinate jurisdiction, I think would be a very helpful one. Because at the moment, this is something that really shouldn't create any problems, but we don't have provisions to enable it. I think it will be helpful and will help to avoid needless rehearing and all of that. Also, when judges are elevated, we need a constitutional dispensation that allows judges who have been elevated to return to conclude part-heard cases, especially where those cases are even very advanced. I think, again, this is an eminently sensible idea. Then there's the use of digital data grids for case monitoring. Now, these digital data grids are very simple, very, very simple tools also. India, for instance, has very simplified its national judicial grid. It collects data on pending cases. It collects data on cases that have been disposed across the courts. It allows the authorities to identify backlogs, to monitor performance, to prioritize resources. And these are, again, very simple tools that can enable us to really speed up our judicial processes and show us where there are deficiencies and where things are slowing down. ADR, Alternative Dispute Resolution, we must also more frequently use ADR, mediation, arbitration, conciliation. Also, we can develop our own online dispute resolution platforms. This is an emerging trend in some African countries that don't even have our own level of judicial development. They already are using online platforms for resolution of small claims and all that. Then the citizens mediation centers. We may use the citizens mediation centers for small claims, although larger claims may also be mediated. The Lagos State experience is quite a good one. I recall at the time that sometime in the year 2000, the then Governor Bola Tinubu, sent a memo to me from, I believe it was real estate agents or so, who are talking of the stock of housing in Lagos, especially middle cadre housing, dropping because most people were investing in stocks and shares and were no longer building middle cadre or middle income type houses. Why? Because once tenants paid the 2-year rent, then they won't bother to pay again. And so if you went to court, if a landlord took them to court, it will take years and years to resolve in the magistrate courts at the time. So many landlords were deciding, look, in the past, people used to think if I have four flats, I should be able to take care of my retirement. All of a sudden, that became a pipe dream. So we then decided that we will start citizens mediation centers. to take some of the work that the magistrate courts were doing. And these mediation centers, we established them first in the Ministry of Justice in Lagos. Eventually, we expanded the scope of these cases, of these centers. In the end, we were able, in 1 year, we were able to resolve 8,000 landlord and tenant cases, whereas the magistrate courts were doing under 2,000. And today, I believe the Lagos State has about 18 or more mediation centers, able to resolve something like 20,000 cases in a year. I mean, these sorts of, whether they are called mediation centers or whatever other small claims arrangement are possible, are the sorts of things I think we ought to introduce to take away some of the very simple, straightforward cases that can be resolved, outside of our regular court system. But it's also crucial that we prevent ADR, especially arbitration, from being hijacked by the regular courts. Courts often intervene in arbitration matters on various grounds. For example, jurisdiction or arbitrability, That will then lead to setting aside or annulment of parts of awards that have been granted by arbitral bodies. Now, this is a major source of interference. The clear provisions of the Arbitration and Mediation Act of 2023 are that a Nigerian court, for example, has no jurisdiction to set aside a foreign-seated arbitration, although you do find courts every once in a while doing that. But the crucial point is that we must, as a matter of legal policy, discourage even more intentionally the interference of courts with arbitration. The moment the court gets into an arbitration, it means that this ADR method is already drawn into the judicial process, and it loses its advantage as a quick method of dispute resolution. We must also, in my view, refine our fast-track and specialized courts for high volume or sensitive matters. Already we have specialized courts now. We have fast-track courts. Lagos has fast-track courts. But I think the major problem with a lot of the fast-track courts is that we must continually pay attention to making sure that they are actually fast-track. Many models of fast-track courts, what tends to happen is that in the first year, 2 years, 3 years, they are actually fast-track. Thereafter, they just become, the normal, fast, slow sometimes, and all that. And it's because we are not paying enough attention. We have to pay attention. If you say a court is a fast-track court, you must keep modeling and remodeling. Keep refining and refining until you get to a point where it is actually just functioning always and consistently as a fast-track court. Corruption cases, for example, should be fast-tracked. In these courts, we must tighten procedural rules to limit adjournments. And this is the sort of thing that should go across our entire justice system. In India, for example, in many of their court systems, especially the federal court systems, there's a maximum of 3 adjournments. Court infrastructure and staffing must also be enhanced to manage caseloads more efficiently. And today, with various AI tools, simultaneous recording of proceedings, production of transcript is much easier and much more accurate. Blockchain technology has great potential to transform transparency in administration of justice. By creating tamper-proof records, it's possible now with blockchain technology, and again, this is available. You can create records that are tamper-proof. Every filing, documents, service or processes becomes immutable. And this strengthens trust in the general justice system. And it provides clear audit trails. It allows courts, litigants, and oversight bodies to see exactly who did what in the process. You can't say a file was lost. You can't say the file disappeared. The file remains where it is, and it's immutable. You can't change anything. Also, a regime of severe sanctions for delays and abuse of process must be instituted. There must be consequence for malfeasance by counsel. For example, the award of adverse and wasted costs is so crucial, and we must put in place a regime that enables judges to be able to award adverse costs and wasted costs. Adverse costs are paid to the successful party in a civil case, and wasted costs are directed against legal practitioners for poor professional standards. Sometimes we find the courts doing this. Severe costs should attend adjournments. There's no greater waste of taxpayers' funds than a scheduled case to be adjourned, and it's only heavy costs that will discourage malfeasance in this way. And one of the points I just wish to emphasize, just on this point of cost, I remember years ago, I was serving at the time as a special assistant to the Federal Attorney General. We had a case involving NEPA at the time. It was an international case, and we were in the High Courts of Justice in England. Our entire team was supposed to have arrived on the particular morning to appear before the Royal Courts of Justice. Our counsel, as the Queen's Counsel at the time, was there in court. We were there in court. But our witnesses from NEPA didn't show up because they arrived that morning. Of course, everyone else had arrived the night before. So we were there sitting down. The judge was sitting down there waiting for our witness. 9 o'clock, 9:15. And the judge said, well, he turned to our counsel and said, where is your witness? And he says, it appears that they arrived this morning from Nigeria and they are making their way here. And the judge simply said to him that, of course, you know that is completely out of order. And yes, he nodded and said, yes, he recognized that it was completely out of order. And that was the end of the matter. We were fined, I believe at the time, about £176,000. That was for that adjournment, £176,000. I mean, there was no question at all that we were in trouble if you were fined, and then, of course, to get another date. But counsel comes to court today in serious commercial cases and says that, my tire got burst on the way, and is allowed to, as it were, even take an adjournment to go and freshen up and all that. So I think that unless we're serious about costs, it's unlikely that we'll be able to prevent the delays, especially those caused by complexities, lack of cooperation from law enforcement agencies, inadequate mechanisms for asset tracing. There are just too many things. Often, judgment creditors will abandon enforcement because of the high costs and the low success rate of the post-judgment process of identifying and seizing judgment assets. And that's a problem. What's the point of going through a whole legal process, an involved legal process, and at the end of the day, you can't enforce judgment? Government debts, of course, are even more notoriously difficult to enforce, especially with the mandatory requirement of the Attorney General's consent before initiating garnishee proceedings to enforce monetary judgment. I mean, there are claims that government owes up to $3 billion, which is, in my view, completely false. And we prepared a report before we left office on this particular point. The P&ID judgments also, similar things, where you found collusion between some government officials and the P&ID officials. So sometimes you wonder whether, just simply allowing a situation where there is no intervention, especially with government resources, whether that's the right way to go. But I believe that we can do more, anyway, generally speaking, to reform the failing system of enforcement of judgments. The first is to remove the obstacles to enforcement. Reduced judicial discretion or automatic or default enforcement mechanisms is perhaps one of the ways that we can do this. For instance, in the US, federal and is also in many states, once a judgment is entered, writs of execution and garnishments are available without further judicial approval in most cases. So once you have the judgment entered, there is it's almost self-executing from there on. In Singapore also, writs of seizure and sale of sale or even garnishee orders are largely ministerial. Once judgment has been given, judgment is the final step. From then on, there's no longer any judicial interference in the process. And this is, the Singapore Supreme Court is said to be one of the most efficient in this respect. They have the sheriff of the Supreme Court who controls and supervises all specialized enforcement officers. Now, this centralized and professionalized system is one reason why domestic judgments in Singapore are considered to be some of the most efficient. I think effective enforcement is a function of executive will. Where executive will is lacking, effective enforcement will also be lacking. The executive branch must see enforcement as priority. The Constitution clearly makes the enforcement of laws, including judgment of the courts, the responsibility of the executive. And I would suggest the establishment by law of a well-trained and armed judgment enforcement corps to replace bailiffs. The law should contain clear operational guidelines, autonomy to act without interference from the police, from security agencies or the military or other armed services, so that this is an enforcement force by itself. See, if you cannot enforce judgments of the court, really, you can't really speak of justice. Now, another reform issue is on the question of the quality and integrity of judicial decision-making. And I think that this is a matter which the judiciary itself must address. This has been a growing cause for concern. There's a lot of concern around this issue. The increasingly established preference for technicality over justice is something that I find, sometimes just astonishing. Because we know that it will always alienate the system of justice from the people that is meant to serve. So, for example, the Supreme Court holding in Okafor and Nweke that signing processes in the name of a law firm instead of counsel was enough to nullify proceedings at whatever stage the proceedings were. And then, of course, this has been reaffirmed. The Supreme Court has had an occasion to look at it again. It's been reaffirmed. Since then, the court has nullified cases that took decades to get to the Supreme Court on account of this technicality. And sometimes I'm just amazed. What's the point of this? What exactly is the point? What if it's not even signed? Can't the error be corrected right there and then? Why should an error by counsel over signatures rob a party of all merits of their case? And to me, how can this make sense to the man on the street? And it's the man on the street for whom this justice is meant. How does it make sense? I think that this overly technistic approach, again, is repeated time and time again. And we must look at it as a matter of policy and insist that it should not be that way. There's a Supreme Court case also, Zachary and Nigerian Army, where this sort of thing was repeated. For those who might have read the case and those who may not have, this was a case involving a Captain Zachary, who was chairman of a task force assigned to investigate the illegal use of nitel lines by Yahoo boys for 419 activities. A court-martial was instituted to try him over allegations that he received a bribe of 40,000 naira from the suspects, and he released some of them, and employees of the company that had been arrested. He was convicted by this court-martial. He challenged his conviction on the basis that the court-martial panel had 4 members instead of 3, and that one of them was his junior. Now, one of the sections of the Armed Forces Act required a court-martial panel to have 3 members, all of whom should be senior to him, or at least the same rank as the accused officer. In this case, 3 of the 4 officers were senior to him, or the same rank as Zachary. The Supreme Court set aside the conviction, saying that once a member of the panel was disqualified, notwithstanding that the officers constituting the quorum were qualified, the entire proceedings would be a nullity. The question that the court ought to have asked, in my view, is whether it was the intention of the lawmaker to nullify proceedings of the tribunal when there was a quorum plus 1, or to ensure that a suspect is given a fair trial, and that in no event should an offender escape. The real question is, Did he get a fair trial? Not the technicality of whether after a quorum was formed, there was an additional guy on the panel. Compare this to the way the court in England handled a mandatory requirement that, if obeyed, should have led to the escape of a wrongdoer from justice. This case called R and Soneji. Kamlesh Soneji and David Bullen were found guilty of, in April 2000, of conspiracy to convert property and move proceeds abroad, knowing the same property to have been proceeds of criminal conduct. The law provided that following conviction, that once individuals are convicted for trying to launder criminal proceeds, confiscation orders must be made within 6 months of conviction. That's what the law provided. But the particular confiscation orders in this case were made more than 18 months after. Despite this infringement, which was mandated by law, was, as we say, it was a shall provision, shall do. The convictions were upheld. Lord Steen said, and this was in the lead judgment, said that it's not useful to ask whether the rule prescribing a 6-month time limit was mandatory or directory. He said that's not a useful question. He said instead the true question to ask was whether the Parliament intended that a failure to comply with the 6-month timetable should deprive the court of jurisdiction and invalidate all proceedings and orders made thereafter. That is, to focus on the consequence of non-compliance with the prescribed time limit. He held that the intention of Parliament was not that non-compliance deprived the court of jurisdiction. He also pointed out that it was in the public interest not to allow a convicted offender to escape confiscation simply because of errors in the judicial process. And I think this is the way to look at some of these issues. We have to come to, just as a matter of policy, to move away from technicality. To move away from Section 6 says it mandates to look more at the justice of the issue, because that really is what the justice system should reflect. How about violations of the fundamental principles of stare decisis or judicial precedent, resulting in conflicts in Court of Appeal decisions, especially, and I think some of the best examples are the 2023 election cycle. I noticed that in the survey also, the 2023 election, this past election cycle, was regarded as one of the worst in terms of judicial outcomes. The Court of Appeal in this 2023 cycle delivered conflicting decisions on whether issues of party primaries and nomination are pre-election matters, or whether they are not pre-election matters, or whether such issues can be raised in election petitions. A binding Court of Appeal precedent already existed. APM and INEC and others already existed. There's a binding precedent which held that nomination sponsorship issues are pre-election matters and cannot ground an election petition unless they relate to constitutional qualifications. Yet, in Plateau State, election tribunals were split despite this binding precedent. There were two panels saying two different things. Some correctly declined jurisdiction over challenges to the PDP primaries in particular. Others, in violation of precedent, assumed jurisdiction and invalidated all the PDP primaries. On appeal, however, all Court of Appeal panels, in violation of existing Supreme Court precedent and the clear provisions of the law, held that the PDP could not validly sponsor candidates, resulting in the mass removal of PDP legislators, in clear violation of Supreme Court precedent. Unfortunately, for the petitioners in these cases, the cases ended at the Court of Appeal. Of course, as you know, for legislative elections, the final Court of Appeal, and the final court is the Court of Appeal. In Imo State, the Court of Appeal issued divergent judgments again. Two different panels issued despite clear precedent of the Supreme Court. So there was a case, Manasseh and Goshwe, I'm sure some of us might have read the case, a case on the Plateau governorship election, where the Supreme Court had an opportunity to reaffirm that tribunals have no jurisdiction over pre-election matters such as primaries and notification. And the Supreme Court delivered one of the most scathing criticisms of the Court of Appeal that I have yet read, describing the actions of some of the panels of the Court of Appeal as amounting to misconduct. Ajim GSC, who read the lead judgment, said, the deliberate refusal of courts to follow the established precedents of this court are principles that have become trite and elementary. I want to just read that portion because I think it's a very important. Sorry. Yes. He said, the deliberate refusal of courts to follow the established precedents of this court on principles that have become trite and elementary, having been subject of restatements in an unending line of cases, is of grave concern. He said it has very serious implications for the sustenance of the rule of law, peace, order, and security of the society. The principle of stare decisis remains the foundation upon which our rule of law rests. This is why our Constitution provides in Section 2871 that the decisions of the Supreme Court shall be enforced in any part of the Federation and by courts with subordinate jurisdiction to that of the Supreme Court. The erratic, this is his description of the way the Court of Appeal judgment. He says, the erratic and wild judicialism that has occurred in this matter from the High Court order of 26/11/2020 all through the Court of Appeal leaves much to be desired and renders access to justice a difficult, if not impossible, enterprise. If we cannot be sure what the law is at any time, then there is no law. An essential requirement of law is certainty of content and application. Once this certainty is removed, it ceases to be law and becomes a tool to be used manipulatively at the whims and caprices of those of us in whom the society has invested its trust to guard and enforce the law truthfully, objectively, fairly, without fear or favor, to yield substantial justice at all times for the public benefit. It amounts to judicial misconduct of a very extreme proportion for a judicial officer to disregard clear provisions of the Constitution and other legislation and the precedents of this court. The whole engagement from the High Court to the Court of Appeal amounts to illegitimate adjudication or false judicialism, flagrant and oppressive abuse of judicial process in an unprecedented manner. I will not say more on this. These few words are enough for us all. End of quote. This is the Supreme Court in that case. Now, it is very clear that the court did not need to say any more. But to the man on the street, the elephant in the room is too large to miss. And this is the whole point of perception. The whole point of perception of corruption. How does anyone who sees what the court did in clear violation of the Supreme Court's Supreme Court president and hearing what Justice Agim had to say? Of course, there's no way in the world that we're not going to wonder whether there was no compromise, whether there was no corruption, whether the outcome of these cases was not induced by bribery or such undue influence. And shouldn't such brazen misconduct anyway give rise to consequences? If conflicts are not induced, they can be avoided. I mean, if you look at conflicts in the cases, for instance, conflicts in judicial cases and all that, if they are not induced, they can easily be avoided. Many of our electronic reporting platforms today, we have so many, Pavilion, Law Pavilion, etc., have the capacity for analytics by simply asking the question about previous authorities on any point. If you ask any of these platforms, you just type in the inquiry. What are the previous authorities? It's very straightforward today. So these are important issues that we have to take into account. And we cannot afford a situation where people get away with this kind of brazenness. It shouldn't. It is, if the Supreme Court said it's misconduct, then it ought to be taken up as misconduct. Then there are structural institutional issues, I think, which need to be dealt with. Inadequate courtrooms, shortage of judges, management of courts, etc. Allocation of cases, docket control, etc. I don't think we need to dwell on inadequate courtrooms, shortage of judges, etc. These are fairly straightforward issues. But how about the administration of the court system? I don't think there should be any argument that administration of court system should be professionalized. How can a judge who managed a single courtroom for years suddenly acquire the capacity to head a whole judiciary and its administrative departments? I think that it really very difficult to imagine how that's possible. I mean, I run a simple court in the corner of Lagos here, and then one day I become chief judge, and I'm responsible for everything, administration, everything in the judiciary of Lagos State. No professional training, no management training, nothing. I think that in some of the discussion we had before we came here, that some suggestions have been made that at least there should be some training, even if some management training. I think the suggestion was that before you become chief judge, you should go to the Lagos Business School, do some management training. Because this is huge. I mean, what a chief judge manages is huge, let alone Chief Justice of Nigeria. It's huge. So I think that these sorts of things are quite important to do. In 2001, Justice Uwais, then Chief Justice, actually proposed a professionalized court administration. He sent around a proposal on this professionalized court administration. In other words, creating a completely different cadre that will manage the courts professionally. The Chief Justice will focus, and judges will focus purely on adjudication and leave management completely to professionalized service. Although this was not followed up, while it simply wasn't followed through at the time. And I think that it still remains how to go about this. Judges should be left to adjudicate, while administration of courts, including procurement, should be the business of professional court administrators. The UK, for example, offers, I think, what is a good model. His Majesty's Courts and Tribunals Service is responsible for judicial administration, including building new courts, renovation and maintenance, and all of that. The service is also responsible for private sector procurement. Whatever it is you are doing, ICT systems, security, furniture, whatever. It can enter into public-private partnerships for court projects, and judges are only consulted for judicial needs, not administration. So I think this is important because really the judge's business is adjudication. It should not be worrying about how courts are built, how much it costs to put in an IT system and those sorts of things. How about docket control and allocation of cases? There are, of course, allegations all the time of bench fixing, corrupt allocation of cases to friendly judges, and these have become trenchant, especially in recent times. Even sometimes in the courts, there are rumblings about illegal payments made to registry staff to get early dates for hearing and all that. I think that the discretion given to heads of courts or registrars in assignment of cases is largely responsible for this abuse. To restore public confidence, there is a need to use structured, rule-based, and auditable allocation systems. And we've got to the point where, again, technology is available. There are a few options, or a combination of some of these options that have worked elsewhere, and which we may adopt. There's a randomized case management approach, for instance, and this is just a computer system where cases are assigned using a secure computer algorithm that just randomly selects the judge or judicial panel. The algorithm would have the capacity to consider workload allocations, workload balancing, sometimes judicial specialization, but it does not allow manual override except under the strictest rules. India's Supreme Court, for example, and several high courts have adopted this model. The Supreme Court and several high courts in India have adopted this model. Again, the technology is very simple, it's very straightforward. Argentina and Chile, in fact, recently they've had some very serious issues of the sort that we're describing. They use a variation of the electronic random assignment method as part of their judicial transparency reforms. They were almost collapsing under the sorts of decay, the destruction of public trust that we're talking about. Also, many European courts use this option, and I think that is an option that we should use just to bring in a bit more transparency, accountability to the entire system. Another well-used option is the automatic rotation or wheel system. Now, this has been used many, many times in the past. Judges are placed in a rotation or in a wheel, and new cases go to the next judge in sequence. So if a judge is unavailable on account of conflict of interest or illness or whatever, the wheel moves to the next judge. And this is one that a lot of federal courts use in the US, the random wheel system. And I think, again, this is very straightforward. The important point is the will to want to do this transparently so that allocation of cases is not a judge's discretion, or the chief judge's discretion or registrar's discretion. It's simple and random and just improves the general trust that we have in these systems. There's also a hybrid option, which enables, first of all, the sorting out of the cases into designated categories, commercial, criminal, or family, or whatever the case may be. And then within each category, judges are then selected randomly. There are very, very many different models, and I think that any one of these models can be adopted. But what sort of reforms are necessary in the appointment and remuneration of judges? I think it's stunning that the process for evaluation and interview of judges, men and women statutorily empowered to literally determine the lives and livelihoods of others, is one of the least rigorous processes imaginable. There are no clear evaluation processes for selection of judges. In the United Kingdom, for instance, where we derive most of our structures, applicants to judicial office, especially to the superior courts, go through several screening processes, including written examinations, interviews, role play exercises. They are subjected to background investigations covering professional credentials, their abilities, public records, their judicial pronouncements, if they have served before, and personal financial affairs. The evaluation by the Bar Association on their integrity is also taken seriously. Professional competence, judicial temperament. It's a whole big thing. Nigeria's judicial appointment system is, and if you look at the proposals, the 2024 proposals, identify that there are so many defects that undermine the credibility and independence of the judiciary. The National Judicial Council, and this is from the proposals, has not succeeded in creating a process that is both meritocratic and transparent, nor one that inspires public confidence. Its guidelines and procedural rules are inadequate, and they're often disregarded in actual practice. The Chief Justice of Nigeria wields excessive influence over appointments, chairing both the Federal Judicial Service Commission and the NJC, thereby controlling initial assessment and final recommendations. The CJN appoints 19 of the 24 NJC members. That's practically all the members, who serve, of course, at the CJN's pleasure. Again, this compromises the independence of the body, and all these facts are properly outlined in the 2024 proposal, signed up to, as we've heard, by the CJN, the President of the Bar, and the Attorney General of the Federation. So these are not issues that are alien or strange. At the state level, the composition of the State Judicial Service Commissions grants governors, again, disproportionate control. They appoint 5 of the 8 or 9 members of the JSC, including the Attorney General, who sits as an ex officio member. Furthermore, Rule 3, subsection 4 of the NJC guidelines gives the chief judges and heads of courts sole responsibility for shortlisting candidates. So it allows them to favor preferred individuals and compromise the process. As a result, judicial appointments at both the federal and state levels are already captured by vested interests, whether those are political or judicial. Governors, attorneys general, and chief judges exercise, of course, overwhelming influence. Not surprisingly, there are several cases of nepotistic appointments, relations of serving judges being appointed and all of that. And, we hear this, we see it all the time. Now, the reform proposals on this issue, I think, are one that we should take very seriously. As a general principle, lawyers and laypersons must have a role in deliberations on judicial appointments, judicial discipline. In other words, they must have a role in the NJC, the FJSC, and the GSCs, ensuring that the bar and the people have appropriate voices in upholding the standards, highest standards that we expect of our judiciary. And this would, of course, require constitutional restructuring of the NJC, of the FJSC, and the GSCs. The NJC and the Judicial Service Commission should be headed, and this is, a view that has been, which has been preferred by many, should be headed by lay persons. In other words, not headed by the Chief Justice or legal practitioners, and their tenure should be certain. Now, this is to ensure independence and impartiality and engender public confidence. And this is the same rationale for the Constitutional Reform Act 2005. This is the UK's Constitutional Reform Act. They provide also for a lay chair for their Judicial Appointments Commission, not the Lord Chief Justice, but a lay person. Second, the NJC and the GSC should have a broad representation of membership from the bar, civil society, organized private sector, and generally the public. Appointment of members should also be merit-based, and we can bring in human resource consultants to draw up formal criteria and design processes to ensure that we get the best results. In other words, members of the NJC themselves should be subjected to a rigorous process of appointment. These are persons who are going to appoint our judges. We shouldn't just appoint anybody. People just shouldn't become members just because somebody nominated them. They should still go through a rigorous process. Vacancies for judicial positions should be publicly advertised. Applicants' identities must be disclosed, and the process must be transparent. Meritocracy should be prioritized through mandatory examinations, interviews, standardized vetting, and clear-cut criteria for assessing candidates. Holistic legislation should be enacted, a whole legislation to codify appointment procedures. And this is what has been done in other jurisdictions. Kenya, for example, since 2011, has a set procedure for appointment of judges. Interview. The issue of remuneration.
Hello.
Thank you very much.
Right. So on the issue of remuneration of judges, for example, while we ask for the best from our judges, we must equally ensure that the conditions under which they operate are not only befitting, but are good enough to attract the best minds in our profession. Judicial remuneration and welfare are critical. Why should a judge earn so much less than a federal legislator, for example? Benchmarking judicial allowances of judges against legislatures. Judges, and I very strong, this is a proposal that we had put forward. I'm not going to go into all the details of that. We put forward in 2021 that judicial officers, their allowances, not salaries, should be benchmarked against those of legislators. So Supreme Court justices should earn the same allowances as senators. Court of Appeal justices should earn the same allowances as House of Reps members. And then we should just define certain sum for High Court judges and all that. Something else took place anyway in the process, and I don't want to go into the details of that. But I think it's a very important thing because there is no reason whatsoever. I recall a particular conversation that I had with the learned Justice Abiru many, many years ago. I think it was in 2000 when he was very happily practicing in very, very successful practice. I think it was at Bentley Edu at the time, making tons of foreign exchange. And I said to now my Lord, I said to him, you have to be a judge. He laughed. He almost fell off his chair. That judge? How much do judges earn? Judges in Lagos at the time were earning 67,000 naira. And of course, I mean, he was earning multiples and multiples of that. And that's really anyway, eventually we improve things and all of that. But I think it's important to bear in mind that you cannot attract the best people if we're not ready to pay. I mean, as they say, if you pay peanuts, then you attract monkeys. So we must pay our judges well. The other point, in 2021, with the approval of the president at the time, we initiated insurance for all federal courts, Supreme Court judges, 7 retired, all Court of Appeal judges and all of that. National Industrial Court, Sharia Court of Appeal, all the federal court judges. And I think that was very important because medical insurance for all of our judges is absolutely crucial. Insurance that enables evacuation if they have. One of the major problems that often occurs is even after the point is owner-occupier accommodation for judges. This is very important. A major issue that was flagged by judges in Lagos State in our own pre-reform meetings in 1999. No judge could at the time build decent accommodation in a location, that in keeping with their status on the salaries that we were paying. So an important component of welfare is a home. And this has been the state since 1999. I think that, again, and I'll just the question of judicial corruption, I think, remains one of the most difficult. The question of judicial corruption, I think, remains one of the most troublesome that we have. It's one of the most troublesome issues that we have. The disciplinary framework for both the bar and the bench, I believe, also requires strengthening. This includes updating of disciplinary procedures, enforcement mechanisms, etc. But for lawyers, I think the LPDC, again, following the 2024 proposal, should be decentralized. Retired judicial officers should be engaged to sit on panels across the country to accelerate and improve disciplinary hearings. At the moment, disciplinary hearings are so slow, sometimes on account of the fact that we can't find the sort of caliber of individuals who can sit on those panels. And I think the suggestion that we could use some retired justices is a good one. A modern performance management system for our courts is important. One that evaluates quality and efficiency and, effective justice delivery, rather than just counting a number of concluded cases. Professional standards must be rigorously enforced, underpinned by training, ethical development, etc. I think that all these things are possible. But again, just on this matter of corruption, I doubt whether there is any factor that's more responsible for destroying public trust in the judiciary as the perception that justice can be bought. In 1999, before commencing our justice sector reform effort in Lagos, we conducted a survey of 200 lawyers who practice in the high courts of Lagos. The new survey that's been done by SP Ajibade is 447, I believe, lawyers. Well, this was 200 lawyers asking about their perception of judicial integrity in Lagos State at the time. 89% said that they felt that judges were notoriously corrupt. 89%. Much more, and much more recently, we've seen there's even another survey conducted by Chatham House on social norms and accountable governance in 2022, a nationwide survey, Nigerian nationwide survey, where 61.3% of respondents believed that a typical judge in Nigeria was likely or extremely likely to accept a bribe to influence a judgment. Now, these are all perception. But the truth of the matter is that when it comes to matters of justice, perception is reality. You are not going to, that's how it works. Nobody is going to say, I found a judge taking a bribe. That is why I believe. It's all about perception. That is why Justice Eshaw said many, many years ago, Justice Eshaw, then of the Supreme Court, said many years ago that even a whiff of corruption around a judge is bad enough. Just a whiff. A rumor is bad. Let alone, look at the perception. So what then happened in 1999 when we had this issue? As I said, a sit down between the executive and the judiciary is always important. I had a meeting at the time with 7 of the most senior judges in Lagos State at the time. And we sat down and asked ourselves the question, how are we going to do this? Everybody believes that judges are corrupt. How can we deal with this? We started the discussion that afternoon. One of the judges, we said, okay, how much do judges earn? 67,000 at the time. We wrote it down. And then we asked ourselves, okay, Justice X, you have a son in America. How much are you paying? He says $12,000. Okay, we'll write it down. You have one in university. How much? We wrote it down. One of them tapped me on the shoulder and said, Leonard Attorney, you two know this thing is rubbish. You know it's rubbish. How can you pay 67,000 and expect people to have children here and there? How is that possible? So it was evident to all of us seated around that table that day that we were fooling ourselves. One of the judges told a story that on that occasion, said, look, my wife called me one afternoon, said our daughter was in St. Nicholas Hospital. She had just been taken there. She was very ill. She was taken there from school. And that we need to make a payment in order to admit my daughter. So he said he rushed to the St. Nicholas Hospital at the time. And they said to him, we have stabilized this girl, but we can't admit unless you pay a certain amount of money. He then said that, he was telling them that, look, I'd have to go back to the courts, hopefully raise some money from my colleagues and all of that and come back. But they said, well, as far as we are concerned, we cannot admit unless you make a payment. He said, then suddenly a man from behind him says, sir, don't worry, I can pay this money because this is urgent. He said, and the man paid. He said, as he was going towards his car, and this is a story that, was told to us on that occasion. He said, as he was going towards his car, his clerk said to him, do you know this man? He said, no, I don't know him. Even if he's an angel, I can't tell who he is. He says, but the man was in our court last week. He says, so the question was, what am I going to do? Am I going to run after the man and say, bring back the money? Or what? So, the dilemma, the problem was very stark as we sat down there. We all agreed that this was a big problem and that we were expecting far too much. from our judges. I visited a judge here in Lagos who was living in someone's boys' quarters, retired judge, who was living in someone's boys' quarters. Didn't have a home over there. Had a home in Ondo State, I think it was Ondo at the time, but did not have a home here in Lagos where he was consul after retirement. So it's evident that unless you remunerate properly, and you've got to be realistic about this, if you don't pay judges well, they have medical insurance, they don't have medical insurance, they are not well paid. It's a big problem. So what did we decide to do in Lagos State? We decided, amongst other things, first of all, we're going to improve judicial remuneration. And we did. I mean, we more than quadrupled payments, especially coming from allowances at the time. We agreed that we would give judges cars, that they would own. Then, very importantly, that they would own their own homes, that they would have homes and they would be their own homes. These are not official homes, these would be their own homes. Very, very important, because today, I don't think that justices of the Supreme Court are entitled to homes of their own. Only the Chief Justice of Nigeria, when he retires, would have a home of his own. All the other justices will not have. Court of Appeal justices will not have. But we managed to do that in Lagos, and it's entirely possible. These things don't cost that much. It's very straightforward. You can do it easily. Judges can be provided with their own homes easily, and it wouldn't cost anything that should raise any kind of should give us any kind of problems as government. So I think that these are very important issues that we need to deal with. So in dealing with judicial corruption, of course, what we then did was that we then decided that, look, any case that comes to us, we're not even going to go through the GSC. We simply send it straight to the NJC. And the NJC will set up a panel. Whatever recommendation, we would accept those recommendations. In Lagos State at the time, at some point we sacked about 22 magistrates. 3 judges also at various stages lost their jobs. It was evident to all that we were serious about remuneration and at the same time serious about discipline of judges, and that's the way it should be. Finally, at the time, in 2007, the World Bank, working with us, did another survey. We did another, so I think the survey was in 2007. Again, 200 lawyers and all of that, At that time, 0% of lawyers said that judges in Lagos were corrupt. 0 from 89%. It's again perception. And it wasn't as though the judges became necessarily born again. No. It was because, first, they were decently paid. Again, they saw that we would be consistent in matters of discipline, because whatever the NJC recommended is what we will do, And all of these things are entirely possible. But in my view, the executive has a principal role to play. If the executive says, we are determined to do this, sitting and working with the judiciary, we can make a world of difference. Thank you very much.
Prof, I need you to please come back. Prof, I need you, because you have to join the panel. Please, let's give Prof another round of applause. So please sit, because we're going to go straight away to the panel conversations. Thank you, Prof. Very insightful, very thought-provoking, a lot to pack from that keynote speech. And I thank the former Vice President for doing justice to this topic. But then Prof has always been excellent, yes? And it's one of the reasons why he had to be the one to deliver this keynote speech. Dr. Ajibade will speak to the other reasons. Yes, we'll listen to our other panelists now on what other reforms are necessary to rebuild public trust and confidence in the Nigerian justice system. It would also be good to hear timelines on when some of these reforms that Prof has talked about and what other reforms they would propose should be put in place and how to measure impact. Because I remember when this video of when this video went viral of justices allegedly singing on your mandate, and then the NJI came to debunk it, and many people said, no evidence, then go explain tire. So it would be good to hear timelines. Dr. Ajibade, over to you to introduce our panelists and to get this discussion going. Thank you.
Free seatings are like Chachangi Airlines. Except for the last one, I'll take the last seat. Well, thank you very, very much, Your Excellency, for that fantastic presentation. Understandably, you had asked for 40 minutes. I'm sure you could have done with a bit more because there's so much to say about this topic. But we will do our best to try and unpack some of what you said. The theme of this year's business luncheon, as has been said, cannot be more topical. I think anybody that is concerned about this country must be concerned about the public perception of our justice system. And in addition to the excellent presentation we've heard from our former Vice President, we've put together a fantastic panel of experts and stakeholders in the justice system to discuss this issue and express their own views, make their own contributions to what Professor Oshibajo has said. In no particular order, but I should say, maybe starting with the most senior judicial officer on the panel, naturally, I think the buck stops with the judiciary to start with before we get to the other stakeholders. On the panel is Honorable Justice Adewale Abiru, Justice of the Supreme Court. So I'll share. It's not a fun fact. It's a fact. For those who may not know, whatever I know in practice today, Justice Abiru was my first pupil master. I smiled when Professor Oshibajo was talking about the money he was making at Bentley do, because that was where I did my National Youth Service Corps, and he was my pupil master. He was the one that my first baby steps in the profession. It was under his tutelage. And next is my lady, Honorable Justice Oludotun Adefope-Okoje, highly respected retired Justice of the Court of Appeal. If you listen to Justice Adefope-Okoje, she recently launched a book in Abuja. And if you listen to her comments at the book launch, you'll know just how passionate and how worried she is about the perception of the judiciary and the justice sector as a whole. Justice Adefope-Okoje, thank you very much for joining us. And of course, Professor Pat Utomi requires little or no introduction. Everybody in Nigeria knows him. He's a well-known, not a politician, a reformer, activist, civil society guru. He and I were at another civil society event just yesterday night where he played a prominent role. Thank you so much for joining us, sir. My good friend, Dr. Charles Adeogun Phillips, SAN, Senior Advocate of Nigeria, a very well-respected international jurist who's practiced law both here locally as well as internationally. Thank you very much for joining us. Dr. Hakim Bello Sage was supposed to join us. He made every effort to be here. Regrettably, British Airways made it impossible for him to arrive. He's arriving, he's probably mid-air now. So he's not able to join us, but he made arrangements for a very good friend of his and another very distinguished Nigerian, Chief Osita Chidoka, former Corps Marshal, Federal Corps Marshal of the Federal Road Safety Corps, and former Minister of Aviation, to stand in for him. Unfortunately, Chief Chidoka also tried to get to Lagos, but he couldn't make it, but he has agreed to join us virtually. Chief Chidoka, you're most welcome, sir. I think you're muted, sir. We can't hear you.
I'm here.
Oh, fantastic.
Can you hear me? Yes.
Yes, we can hear you now. Thank you. Thank you very much. Thank you.
Excellent.
Yes. So just to give some background, in addition to what Professor Ajibade was so kind enough to say in his remarks, this journey of justice sector reform, it's something that we at SP Ajibade and Co. generally and personally is something that I've been committed to for a long while. It's not just about passion. I think that if we don't fix these problems, we're not going to make much headway in this country as a nation. I think these problems are foundational. And I'd like to seize the opportunity to thank a few people in the room who have given me the impetus to take this passion or this concern even further. One of them is my very good brother, former president of the Nigerian Bar Association, Olumide Akpata, against whom I contested for the office of president of the Nigerian Bar Association, but who, despite the fact that I lost to him, but because of the passion that he knew I had for this issue, appointed me as chairman of the NBA's Judiciary Committee, and which was the first platform on which we built the Justice Sector Summit of 2022, which was ably and very, very strongly supported by the Vice President, the then Vice President, Professor Ajibade, and his Justice Research Institute. And also in absentia, the Olumide's successor, YC Mekia or SAN, who also, because I guess he saw what we had done in 2022, renewed my appointment as chairman of the Judiciary Committee, which led to the second summit we held in 2024. And then my very big brother and good friend, the Honorable Attorney General of the Federation, who stepped into Professor Ajibade's shoes, because Professor Ajibade gave us executive support for the 2022 summit. Now the Attorney General gave us executive support for the 2024 summit. And it's important to say this because I kept saying to Professor Ajibade and the other speakers that this is not really to talk about what the problems are. These problems have been articulated time and time again. Anybody who reads the communique of the 2024 Justice Sector Summit will know that we know what the problems are. We have actually proffered solutions. The problem is how we move from talk to implementation. That is the real challenge. And Professor Ajibade in his keynote has also addressed some of these concerns about implementation and solutions. So I'm going to dive straight in, asking the panelists to share their thoughts. We have a virtual audience, and we're going to ask the virtual audience to please, if they have any questions, they should please put them in the Q&A, not in the chat, because we're going to try to address as many of those questions as we can as the session progresses. The Professor Ajibade has used his vice presidential privilege to take a bit more time than was allocated, so we are pressed for time. But so I will urge the panelists to please try and be as concise as possible so we can try to get back on track. And the first panelist that I'm going to call on, of course, again, is Honorable Justice Abiru. Justice Abiru, Prof mentioned this already in his keynote. The research paper published by Chatham House, which referenced the concern about the perception of corruption in the Nigerian judiciary. Now, we also, as you are aware, and as Prof has mentioned, conducted a survey which shows that that perception has not reduced. And to the extent that it is just a perception, as a justice of the Supreme Court, you stand at the peak of judicial responsibility. Drawing from your experience and your position, can you give us a sense of the reaction of the apex court to this perception of corruption in the judiciary? And drawing from that, help us understand the responsibilities the bench must shoulder at this critical time to alter this perception, how you think judicial officers should act differently, and what, in general terms, the judiciary should or can do to address this perception of corruption.
Good morning, ladies and gentlemen. We're still in. Good afternoon, ladies and gentlemen. Let me start by thanking Tunde Ajibade SCN for having me here. And also let me bring to you the glad tidings and the warm regards of the Chief Justice of Nigeria. She couldn't make it. She had to represent her and to just send her regards. Having said that, let me enter a caveat. Whatever I say here are my personal views. And views of the judiciary, and views of the Chief Justice. They're my personal views. You said perception. I mean, Prof has been very kind, Professor George, in talking about perception when he spoke, that it's a view, what people feel. Now, in Nigeria, when the system doesn't work as effectively as it should work, and we all know that our judicial system is not efficient. Let us be honest, very efficient and very effective in terms of disposal of disputes. It takes, like Prof said, an average of 13, 14 years for a case to move from the High Court to the Court of Appeal to the Supreme Court. So even at the end of the day, if you win the matter, you've lost in terms of value of time. So the perception grows that, look, for a system to work like that, for things to work like that, something must be wrong. And corruption is one of the easiest things that people hold on to. Look, to deal with this problem, many solutions have been proffered. But let me just put it in perspective. Professor Shibaj spoke about 1999. When a survey was carried out in Lagos, 89% of people surveyed felt that judges were corrupt. Now, what did they do? Because I want to use that to bring out examples. There was a single operation carried out. Magistrates were sacked from that. Some judges had to leave because of a short panel, whatever. Now, there was an appointment process that took place at the time. They appointed 26 judges. I was one of them. I didn't want to come to the bench. I was persuaded to come to the bench. But what I saw from the exercise was that there was a rigorous focus on picking people of capacity, character, and integrity, and appointing them to the bench. That was that exercise by the Chief Judge of Lagos, Justice Shegun at the time, by Professor Ajibade, and by some very senior justices. They were selective in reaching out to people and calling them to come to the bench based on what they perceived of you, character-wise and integrity-wise. Now, when we were appointed, we had like a 5 weeks or 6 weeks training before we started sitting at all. We had training at advanced legal studies. We had training we did computer training. We had training when we went to Akodo at the time. Now, the computer training that we had made you understand the fact that you were expected to use a laptop. Upon that point, we were given laptops to use. Now, what the training did for us was that it made us form a bond and gave us an understanding that judicial work was service. So the professor spoke about the philosophical understanding of what judicial is about. It's about service to you're servicing, you're providing a service. Now, providing a service, you must be aware of your service, your people you're providing service for. You must have a concern for them. Now, when we were deployed and we started sitting, after about a year, Prof told at the time they did another survey. And the position was that, look, there was zero corruption in the judiciary. Now, what did that show? It showed that, look, you must be very deliberate in choosing people you appoint to the bench. You must have a clear system that is based on merit, that is based on principle of character and integrity. You cannot teach character and integrity to people. You either have it or you don't have it. Justice Shegun at the time made a comment. He said, I prefer a judge who is of good character and is honest, but is not too knowledgeable because he can learn. And a person who is very brilliant, but has no character and integrity because you cannot teach that to him. Now, where the appointment process is that rigorous and they come onto the bench with the knowledge that we are going to serve, it changes the perception and approach to judicial work. Now, also when we started working, there was a gentleman at the time who was like a nuisance, but of value. His name Adesina Odegunlano. He had a magazine called Squib Magazine. Now, what Squib did, we didn't like him because he focused on judiciary, but he monitored the sitting time of each court. And every week he issued a magazine publishing that court 1 start at 9 o'clock, court 2 start at 10 o'clock, also did. And it became an issue because he didn't want your name to go onto the Squib magazine that you were sitting at 11 o'clock. So it's also forced people to start sitting on time. Now, what does this mean? That there should be a monitoring system. There should be a monitoring system as to judges when they sit. And it's not, what NGC does is we do evaluation, performance evaluation. You should deliver at least 6 judgments in a quarter. It doesn't monitor when you sit, how long you spend sitting, what you do when you are sitting. Because if you have a monitoring system, it makes you more accountable. It makes you know that people are watching what I'm doing. Today, it's not there. So you have some judges, I've had complaints, who sit at 11, who sit whenever. Now, if this itself gives off the wrong views to most of the public, that they're not serious. Also, and then it also shows the importance of having some level of media involvement and outlook to the system. Now, when we talk about criticism, probably people have a criticism that when they criticize judges, we feel as they're talking to us. Yes, that is true. Particularly where the issues are unfounded. You get a bit upset about it. The criticism about judges who are singing mandate. I was at the conference. I was in the front row of the conference. No judge sang anything. The theme was played when the president got up to go and speak. And it is customary, we all got up when the president got up and sat down when he got to the podium. It was at that point that the theme was played. Nobody sang anything. Now, such criticisms upset you because it's a misrepresentation and it gives the wrong impression about the judiciary. Well, other than that, I'm sure criticisms that are, look, if you are servicing the public, you must accept criticisms. So I think that in terms of what can be done and make things better, appointment process, making the judges themselves individually more accountable by monitoring what they do, and then also there must be some sort of the punishment process also has to be very open and very clear to people. So I think I will take other issues when questions come. Thank you.
Thank you very much. Thank you very much, my lord. My lord, I will take you up on just 2 points, but before I do so, I'd just like to read the conclusion of the analysis of the survey that was carried out by our consultants, We Create. He says, conclusion, a system at breaking point. This survey documents a justice system in profound crisis, with 3/4 of respondents rating public trust as poor and 7 in 10 observing a decline. The situation demands urgent, comprehensive action. The convergence of corruption, political interference, and systemic delays has created a perfect storm, eroding the very foundation of the rule of law. The stakes: democracy cannot function without a credible judicial system. Economic development requires legal certainty and contract enforcement. Social stability depends on peaceful dispute resolution, and national legitimacy flows from fair, accessible justice. The window: when a majority of legal professionals have personally witnessed trust-eroding incidents, when young lawyers enter practice already disillusioned, when citizens choose self-help over courts, the tipping point approaches.
Yes.
The legal profession's rare unanimity on systemic failure presents both crisis and opportunity. And it says the path forward: reform must be comprehensive, not cosmetic. Judicial independence isn't negotiable, it's foundational. Transparency cannot be optional, it's oxygen for legitimacy. Accountability must have teeth. Consequences must follow misconduct. Technology should enable, not just modernize. It must reduce corruption opportunities structurally. Most critically, as one respondent powerfully stated, the public needs to see consequences.
Yes.
Without visible accountability, all other reforms ring hollow. The restoration of public trust begins with demonstrating that no one, judge, lawyer, or politician, stands above the law. Now, the point I want to make to you, you've mentioned it, and Professor Shibaju also mentioned it. You spoke about a sting operation that took place then, which was evidence. One of the things that must have driven down that perception of corruption then was the evidence that the executive was actually prepared to do something. Professor Shibaju made reference to the number of things I'd sent to him. One of the first things I sent to him when he took office as vice president, it's a paper, I've still got it. I said, taking the fight against corruption to another level. I didn't even know about this sting operation. That was what I was recommending on a national level. That if you really want to deal with corruption, we know the judges, get some people, we know you say judges take bribes, get somebody to go and offer them a bribe. If you get 3 or 4, or get even judges to invite lawyers, you want to give bribe, come, I'll take it. And then get them, let's show that there are consequences for bad behavior.
Yes.
Now, that for me is critical. That we must be prepared to actually do something and be seen to do something about this, because there have been comments from the judiciary recently that it's almost like we're in denial. You know, we have this perception on the part of the public, including the profession, or you have members of the judiciary who will say, show me proof. It's not true. Judges are not corrupt. And that in itself sends the wrong signal. Because at first, you cannot solve a problem if you don't even acknowledge that the problem exists. So, my lord, sir, I mean, I'm not, as I said, not to put you on the spot, and I know that you can only say so much. As a matter of fact, that's why I'm so happy that I have a retired, a retired jurist here who might be a bit more willing to poke the bear, so to speak. But the next question I think I'll put to my good friend, Mr. Adeogun Phillips, because there are two sides to this problem. It's not just it's not the bench alone, it's the profession as a whole. And Mr. Adeogun Phillips shared with us a paper this morning, which I'm sure would make a fantastic tour de force on this problem. But he's going to hopefully help us to summarize what he feels the role of lawyers is. So lawyers play a decisive role in shaping how the justice system is perceived. From your practical experience, can you speak to the responsibilities that rest on legal practitioners in rebuilding public trust? What must change in prosecutorial conduct, in advocacy standards, professional discipline, and day-to-day engagement with clients and institutions to show that the legal profession itself is committed to reversing this negative perception of the justice sector? Charles.
Thank you. In answering this question, the theme of the recently concluded MBA General Conference, stand out, stand tall, readily comes to mind. Personally, I would have tweaked that theme somewhat to read, we stand, we rise. And I say so because in my humble view, we first must stand before we can rise. Now, in terms of ethics and honesty, only building contractors, politicians, and car salesmen have lower ratings than lawyers. Part of this, of course, can be explained by the fact that a client sees a lawyer as a means to justice. So if they lose a case, be it a criminal case or a civil case, the lawyer and the system are easy targets of blame. That's obvious. But of course, it is also the case, I dare say, that lawyers have divided loyalties and responsibilities, a duty owing to a court, whilst at the same time owing a duty to a client. And on occasions, on several occasions, these duties will be in conflict. But we all know that where there's a conflict between our duty to the court and our duty to a client, surely our duty to the court must prevail. In practical terms, what does that mean? Well, it means that our duty, our responsibility extends beyond merely representing our clients in court or just sounding as a mouthpiece for what our client wants known. We cannot exist by serving as a mouthpiece for our client, but rather we need to uphold our independent and overriding duty to the court. Well, that in itself is not always understood by many lawyers who carry the notion of the duty to the client too far, and in that regard engage in practices that are completely unethical and then go on to defeat the interest of justice. There's so many examples, but I'll give you my example. Beyond all the political intrigue of the investigations and the prosecutions of judges in 2016, which I was directly involved in, that whole process revealed to me a very disturbing pattern, that of legal practitioners sending electronic payments to judges. The explanation at the time were these were gifts. They probably were, and I have no doubt that we have a tradition in this country of offering gifts. And in that regard, I went to great lengths to explain to my colleagues, my fellow investigators and prosecutors at the time, that it was necessary for us to make a clear distinction between those lawyers who offered gratification to judicial officers to influence the outcome of matters before them, and those whose conduct was clearly due to the exercise of poor judgment. And this is where ethics and the regulation of our profession comes in my view. A commitment to legal ethics involves a commitment to the introduction of finer codes of ethics and standards of professional practice beyond those that are contained in the Legal Practitioners Act. So, rebuilding public trust, in my view, requires lawyers to recognize that we're not merely advocates for our clients, we have an overriding duty to the court. It means also resisting the temptation to act as mouthpieces and conduits of corruption and the inappropriate patronage of judges, and embracing strict rules. The legal profession's collective reputation is our most valuable asset. And if we fail to police ourselves and uphold the highest standards of integrity, we risk not only our professional standing, but the very foundation of the rule of law in Nigeria. So the time for half measures has passed, in my view. We must stand on principle before we can rise in public esteem. Now, what must change in prosecutorial conduct? Because this question has been lopped with the first one. Well, two things, very clearly. The first, again from my experience of prosecuting judges, is the abuse of prosecutorial discretion. Prosecutors carry a very huge responsibility in the sense that they can exercise discretion to file charges against members of the public. And it is this responsibility that they should not, in my view, seek to abuse. It is of equal importance that prosecutors are also able to exercise that discretion independently and free of political influence. When I was involved in the prosecution and investigation of judges in this country, which was unprecedented almost 8 years ago, soon after my appointment, I began to realize the sheer impossibility of the assignment. It was just an impossible assignment for various reasons. Let us just say that there were very strong indications of the abuse of prosecutorial discretion and the use of political power to settle old scores. But that was 8 years ago. More recently, I have been involved in cases where there has been an abuse of prosecutorial discretion in deliberately commencing criminal proceedings in this country against defendants in what, in my view, was essentially a commercial dispute between shareholders in a company with a view to securing an out-of-court settlement, which essentially forces one defendant to relinquish shares in the business. Clearly, an abuse of prosecutorial discretion. So how do we guard against such abuses? Well, my suggestion is to introduce, and some people have said that we have it, so if we have it, then we reintroduce. We had it, so we reintroduce it. What we know at the International Criminal Bar as the indictment confirmation procedure. It's a process where criminal charges, together with the supporting material, which we call proof of evidence here, are submitted by a prosecutor to a judge, who then screens and confirms the charges on the basis of a prima facie, or the existence of prima facie evidence. And this is what is known as the indictment confirmation procedure. Now, we have a watered-down version of this in the context of remand proceedings before magistrates' courts. Section 264 of the Administration of Criminal Justice Law in Lagos is an example. But the evidential standards in these proceedings are extremely low. But beyond the evidential standards, the question is this: why commence remand proceedings to show probable cause before a court which, for the most part, has no jurisdiction to try the offense in the first place? That is something that I hope will change in this jurisdiction, because you take a matter that is triable in the High Court and the Superior Court to the Magistrates' Court, and you ask the police to show probable cause at the stage of remand. That court has no jurisdiction to try the offense. The second issue that disturbs me in terms of the prosecutorial experience is the disclosure of evidence. And in my experience at the International Bar, the disclosure of evidence is a matter of perpetual debate between the defense and the prosecution, either from a prosecutorial point of view or from a defendant's point of view. It is always late, it is always incomplete, and in the case of potentially exculpatory material, it is completely non-existent. Now, in this jurisdiction, it is troubling that there is no provision for the disclosure of exculpatory evidence. Now, that is in itself impinges on constitutional guarantees in Section 36, the presumption of innocence. You are innocent until proven guilty. It also impinges on the fair trial rights of defendants in Section 36(5). It impinges on the principle of equality of arms, where a defendant is entitled and the prosecutor has the responsibility to disclose material which is under his or her control, which may assist the defendant in exonerating him or herself. This duty does not explicitly exist in the ACJA, but it does by implication, in the sense that you can request a judge for the disclosure of any other relevant document that the court may direct. But the practice direction of the Federal High Court, Rule 4, actually goes on further to encourage prosecutors to disclose every material that would be of benefit to the defense. The only difference in the ACJA and the practice direction of the Federal High Court is that the ACJA does not impose any limits. Now, what is a disclosure obligation where there are no time limits set? If you're disclosing evidence to me at the end of the prosecution case, it hasn't helped in my investigation or in my preparation for the defense case. But perhaps the most professional conduct, the rules of professional conduct for legal practitioners in Nigeria, Rule 37(6), actually requires us not to suppress, but to disclose exculpatory evidence capable of establishing the innocence of accused persons. Now,
so Charles, I'm going to have to stop you just because of time, but thank you very much. Like I said, this paper, I had the privilege of reading it. It is very rich, and we're going to circulate it to all the attendees. But I'd like to take you to one specific aspect of this part of the discussion, which is the role of legal practitioners and whether we ourselves are holding ourselves to the right standard. Because, the provisions are there. The question is, lawyers are behaving badly day in, day out, and we're not seeing, at least the perception is that there isn't a sufficient appetite to deal with that bad behavior, and that's why it's getting exponentially, it's increasing on a daily basis. I mean, I'm sure you have your views on that, but I'm going to move on now to my next question, which is for Mr. Hakim Bello Osage and will be taken by Chief Osita Chidoka. And this really is the impact of this perception on the business community. So the question goes thus, Chief Chidoka. Business and citizens depend on predictable and fair systems, and investors rely on justice institutions to operate with integrity and efficiency. From your work across the economic and governance space, what are the consequences of the poor perception of Nigeria's justice sector on our social and economic advancement? And what steps do you feel we need to take to address this perception? What are your views on the practical steps that Professor Ajibade has proposed that the justice sector institutions should take to restore trust? Do you think they would boost confidence amongst the business community and the public? And what additional steps would you recommend? Chief Chidoka, you have 8 minutes, sir.
Thank you very much, and I'm happy to be here, but I must warn that much as I'm representing Kim, I do not have his vast experience in business, so I will be talking both as a friend, a young lawyer, and somebody in the policy space. But I had some privilege of some thinkings with him over time. So I want to say first and foremost that trust is now the judiciary's most valuable currency and its most exposed vulnerability. So trust is no longer a slow-moving sentiment. It's not a sentiment that people can arrive at over time. So it's very volatile. Trust is almost perishable. So once a video comes online now, in a matter of minutes, a reputation can be destroyed. Once a post goes viral, the whole world is seeing it, or a judgment that appears inconsistent with public perception, then you damage reputation immediately. So that's why I want to say that the judiciary's problem is not just operational, it is reputational. And listening to what Professor Shibanjo, the former vice president, have said, he has very much well outlined it out. But the critical question for me is, who takes responsibility for judicial reputation? And I'm going to bring all this together to how it impacts the business environment. Who is really responsible for the reputation of the judiciary? The judges as a whole, do they come back together and think about their reputation? Is it the NJC? Is it the Chief Justice of the Supreme Court? Who really is the final responsibility person? Because the president is the responsibility person for the executive. In the legislature, the Senate president and the Speaker of the House, whenever the House is under attack, those are the leaders we see come forward. So if the judiciary has somebody who takes care of its reputation, then that person or group of persons will then have a responsibility to bother about the stature, the nature of this reputation. Because it looks to me like we say these things blanketly. So the judges themselves have no incentive to be good, because everybody just says the judiciary is corrupt. So even if you're an honest judge, the incentive is very limited, because anything you do, people will say, oh, it's the judiciary. So the damage to the reputation of the judiciary spreads to all judicial officers, and then, of course, to the legal practitioners. So from the SPA survey, we saw that 73% of the legal professionals say the judiciary trust is poor. 65%, say the trust has declined over the past 5 years. So, and 78%, if I'm correct, believe judicial independence is weak or compromised. So this is a crisis. It is a real crisis of institutional integrity. And what the keynote told us, and it told us very well, Professor Shibanjo's keynote, identify courts continue to interfere with arbitration process, fast track courts to lose momentum, adjournment culture, judgment enforcement, and his message was clear. Nigeria is running a 21st century judiciary on a 20th century operating model. So, and I agree, it can work. So the judiciary suffers not just from process failure, it suffers from what I call visibility failure. It suffers visibility failure. When I became aviation minister, one of the things I did was to get the data from NAMA of airlines' fidelity to their schedule. So we just track the schedules of airlines and the actual time they took off. The tower has that information. So we automated it, and I get daily reports, and then at the end of every month, I will announce the airline's time performance on my, I just only announced it on my Facebook and Twitter. And guess what happened? From 30-something% average when I first started it, by the 4th month, we're already at 60-something% average, because every airline wanted to be removed from the list of infamy. So at that time, Air Peace had a drastic increase, Arik Airline, in their on-time performance, because I was publishing that data to the public. So the judiciary suffers from a lack of visibility that is giving it problem. Now, the framework I have for their renewal is that the damage is community. And I am a witness to this, because even as a government official, when we have commercials, we take them to get justice from the Nigerian judicial system. And that means that most times we either twist them, force them to do what we want, or the contract just goes bad and everybody walks away. And sometimes they take our money, and we know that it's going to take us forever to get it back. Every business in Nigeria suffers when the judiciary is perceived as not functioning well, and when the reality is that it is not functioning well. We had an American partner who insisted that they will need a Nigerian front business who they can sue in the US, and that Nigerian front business will be the person doing the contract with us, and they will stay in the background because they have no trust in the Nigerian judicial system. So we see that this puts additional cost on businesses. But I think that if the judiciary will take a framework for renewal, I call it the M²I, measure, monitor, and improve. So the keynote speaker have spoken about the visibility, the technologies that are available today to track performance. We need to begin to measure. We must begin by measuring what matters. So case inflows and clearance, because like the survey said, and everybody has been saying, the cases that damage the judiciary in Nigeria are usually the high-profile political cases and sometimes some commercial cases. So if you sequester those cases, they are probably 1% of the total cases in Nigeria that are slugging through their way through the courts. So we need to know how many cases do we have in Nigeria? How many judgments eventually went on appeal? How many judgments were actually enforced? So if we can begin to measure and publicly, the public may begin to find out that, oh, okay, out of 1 million cases, it's actually these 10 cases or 20 that is that the judges, that we report in the newspapers. So I believe that the judiciary's perception is defined by the minority of the cases, not by the majority. Of course, there's a general delay in the system caused by administrative issues. But when it comes about the perception of justice, it is these minority cases that are in the public domain that has done most irreversible damage to the performance and the perception of corruption in the judiciary. So you cannot fix what you cannot measure. Once we're able to identify what we're measuring, we can then go into monitoring. This is the transformative step. We have a public-facing judicial dashboard, updated monthly, showing this number of cases filed. And the keynote speaker talked about all the technologies available today and the examples from Singapore, the UK, and India. So we need to improve. We need to use that data to drive process discipline. So if we know that judges are now delaying cases, cases averagely cost us 3 years in one court to get through, and then 14 years in the whole gamut, it means that we must begin to seek improvement. And those improvements will be that once we can measure and monitor, improvement becomes natural. You will see that many judges will not want to be seen, like the earlier speaker mentioned about, the judge mentioned, my lord mentioned about judges being put on the spot, like we put the airlines on the spot. There is bound to be likely to be improvement. So automating all predictable steps in judgment enforcement, removing the bottlenecks, such as Attorney General's consent for execution, as has earlier been said. So trust dividend, why these reforms matter is that if we rebuild trust, we unlock the national gains. Of course, the economic confidence is the key part. Investors choose jurisdictions where, contract enforcement is predictable. Reducing interference with arbitration, we boost our credibility instantly. And then, of course, political stability. The political stability part is like the example he gave of the Court of Appeal and the quote from the Supreme Court. That's consistent inconsistency in judgments, even when the stare decisis, the precedents are clear, is something that needs some form of punishment, some form of response.
I like that, Chidoka, consistent inconsistency. I will.
Yes.
I will quote.
And then, of course,
I will quote you on that.
You are permitted. And then, when the court loses legitimacy, citizens resort to self-help. Most of the self-help issues we have in Nigeria today is almost a total distrust of the judicial system. The survey already shows that even young lawyers are becoming disillusioned. And then, of course, institutional reputation. A transparent judiciary is resilient against misinformation and political pressure. So trust must be engineered, not assumed. We mustn't think that people will just trust if we start doing well. No, we need to show that we're doing well. Judiciary needs to earn the trust, because trust is a commodity. It needs to be earned. It can also be destroyed. So the world where perceptions spread faster than judicial reasoning, visibility is no more optional. It's a thing for survival. So if we can measure, if we can monitor, and if we can improve and create this visibility that other speakers have talked about using the technologies that are available. Because I always say that the challenge of Nigeria for me is not usually policies. It's the fact that we are not an evidence-based society. I gave a recent example, and that's my conclusion. I'm giving an example from a sector I know very well, the Federal Road Safety Corps. They publish annual reports telling us in 2027, 5,920-something people died from road crashes. And they said these are the top 6 places where they are dying: Kaduna, Lagos, Jigawa, Niger, Kogi. Yes. And they listed the routes, and they said 65% of the accidents is by overspeeding. They also said 70% were caused by commercial vehicles. Then the 2025 budget comes out. They have 3 billion for capital investment. 85% of that 3 billion is for, I'm just rounding this up. 85% of that 3 billion is for purchase of houses, not for action on the 6 corridors where 5,000 people died, not for equipment on the places, not for reducing speed, not for going about the states where the crashes are. It is for purchase of houses, which is important for the core members, but it's not reflecting on the data of where we're going. And that for me is the problem in Nigeria.
Thank you so much, Chief Chidoka. Thank you so much. And you know, you've spoken to an issue that has been recurring ever since Olumide's presidency. We've been working on trying to get a court monitoring system in place. His Excellency, the Vice President, has also spoken about it. And you've also told us now that even within other sectors, road safety, aviation, that is what has helped to increase or improve performance. What you don't measure, what you don't track, you cannot improve on. If we had gotten this court monitoring, and I'm looking at my good brother, Osaro Ehobame, he and I have been in the trenches on this for how many years now? If we can just get a court monitoring system in place, in other words, not squib now, a formalized monitoring system where you're getting systematic reports on what the courts are doing week in, week out. The judges will sit up because they don't want to be in the naughty corner to say you're the one that for a whole month you weren't sitting, or you only did 3 cases in 2 months. So we need to get serious, really, is I think the message. We really need to get serious. My lady, I'm coming to you now. As I said in passing, and it wasn't to say because Honorable Justice Abiru had told us that he was speaking as Wale Abiru, not in the judiciary, but the fact still remains that he's not retired. He's still serving. But my lady, you are retired. So at the National Summit on Justice, which held last year, you spoke on improving the constitutional framework for budgeting, funding, and administration of the judiciary. And recently at your book launch in Abuja, you spoke frankly about the challenges that must be confronted in the justice sector. I'd say not just frankly, I'd say passionately. Given what has been said so far about the lack of public trust in the justice system, the recommendations for reform, what behaviors, administrative practices, and institutional changes do you think the judiciary should champion to help the courts regain moral authority in the eyes of the public? And what will it take to move us from talking about reform to actually implementing reform? You were part of the Justice Sector Summit in 2024. You were part of the workshops we had even before the summit. You were part of formulating those resolutions. But there's a sense that those resolutions are still, to a large extent, just on paper. So what do we need to do to move from talk to action?
Well, first of all, I will take on the NBA because I don't believe that they are doing what they should. We talk about meritocracy. Now, the NBA, there are 5 members of the NBA on the NJC, quite apart from the other members. I had an occasion to take on the president of the NBA. I won't say who he was at that time, because there was a complaint about justices that were appointed to the Court of Appeal at the time. And I asked the question, I said, but you were a member of the NJC. Why did you let those appointments go? So my challenge to them is that they, number one, do not complain about what you permit, because you are the representatives of the people to make sure that the best people get to the court. And if you don't do that, who is going to do that? So I challenge them now that the president is a member. There are other 4 people that are members of the NJC. Speak up. If you see what should not be, speak up. Because where there, a judge that is not capable, it will show up in the system. It will show up. So you are the gatekeepers. Secondly, I noticed that from the Court of Appeal to the Supreme Court, I don't believe that there is any monitoring. Basically, it is political, and it is place saving, if I'll be honest, because you will find out that there's a part of the country believes that they have the monopoly of the CJN, Chief Justice of Nigeria. So whilst from other places, they may come in older, so that even if you get to the seat of the CJN, you're not there for any length of time. But when you bring in somebody that is much younger, and there is a plotting that by this time, this person will be up there, and then can be there for a length of time. That should not be allowed. And it's the MBA that I'm going to take on to make sure that only the best people get there. And we must confess, my brother here, he stops. I would vote for him any day. But it is not everybody there that I would vouch for, so that is a problem, I believe only the best. In Kenya, they have a selection process which is very rigorous, and I think that should also go for all levels of the court, I encourage legal practitioners to come, because I don't think I'm biased, but I find out that a legal practitioner on the bench usually makes a better judge. Because, pardon? Oh yeah, private legal practitioners. They make, a better judges because you're used to pushing the system, and you have a wide sense of justice. Because when you've been through the ranks, you're not going to sit there. I mean, when we're in the Court of Appeal, I was privileged to be with Justice Abiru in Kaduna State. Now, Kaduna State at that time covered Kaduna, Kano, Jigawa, Katsina, and you find judges would come from Jigawa or whatever, and just because of an issue in the record of proceedings that the other party did not object to, one of our colleagues would say, no, this was not signed by this. And I'm talking under the table, my Lord, let it go. The other, a counsel on the other side is not talking about it. They are coming all the way from Jigawa. Let it go. But no, the signature is not there, and that's it. So that sitting is aborted. You understand? So, I found out in a lot of cases that you're talking about technicalities. It was the vice president that talked about technicalities, taking over from a form, from substantial justice. Yeah. Somebody people that come in from the magistracy, that come in from the government, sorry about that, but it's the truth. They would major on technicalities. Whereas if you're in practice, when you're used to asking the judge that, Lord, my Lord, let this go. This is, so when that comes up, you're going to base your judgment on, look, get to the substance of the matter. This one does not count. So I encourage whatever laws we make, I think the NBA should put up a strong position that they should form a percentage of judges that are appointed to the bench. And then appeals. The appeals that go to the Supreme Court, they have to be limited. They have to be. It's not everything that should go. Some should terminate at the Court of Appeal. And I will take this opportunity to say, election appeals, we have to look at it seriously. I do not see why governorship appeals go to the Supreme Court. They are, out of all the other positions, senatorial, presidential, governorship, it's only governorship that has 3 levels. The tribunal, Court of Appeals, Supreme Court. Why? Why? It's not necessary. Even the presidency has 2 levels. You start from the Court of Appeal, you go to the Supreme Court. So, and it should terminate at the Court of Appeal. It doesn't need to go to the Supreme Court. And any moves to take the other levels to the Supreme Court, I believe, should be resisted. It is not necessary. Cases that take only about 5% of the court's docket must not take the lifetime of judicial processes. It is stultifying everything. So I think we should get rid of that. You talk about corruption, I think we should go whistleblowing. Because if there was an article by Babatunde or Babajide Ojudu, where he talked about pre-recorded judgments, well, I've never seen that, but he claims that there's some judgments that are written by
outsourced judgments, my lady.
Please. So what it is that, for you to write a petition, to the NJC, you have to write your name. And it's not everybody that wants to put their names to that because, number one, you're going to be vilified. If you're a lawyer, you can be disbarred if it is found not to be substantiated, even though it may be true, but it's not substantiated. But if you have the whistleblowing, it's a quiet thing. You talk to whoever it is, they will investigate. It's like the sting operation. But I don't like when you say sting because then you are baiting. You shouldn't bait the judge, but at least you can whistleblow. So, and then we've talked about backlogs. I talk about backlogs a lot of the time. It has to be something that has to be intentionally done. It doesn't go on its own. And my Lord, Justice Abira and I were in Malaysia and Singapore when we looked at their court system, and in their court system, they had some very bad backlogs. And, I think it was the Chief Justice now, set up a task force. And they decided that, okay, you have the new judges, you have the, older ones. Okay, let the older ones take up maybe the pending cases, maybe the new ones should take the part-hard cases. And because they faced it with a passion, they were able to get rid of the backlog. So the backlog is not going to go away. If you don't do something about it, it's not going to go away. And that's what's killing our justice system. Right.
Thank you very much, my lady. Thank you so much. You've touched on several points there. The one I would like to latch on to, which was part of our recommendations from the 2024 summit, is really about the promotion system, the seeming automatic promotion in the higher courts, where the most senior judge becomes the head of court, irrespective of capacity or capabilities. I think that is a serious challenge, and also the lack of measure. Once you're in, it seems that once you're in as a high court judge, going further from there is more political than merit-based, because performance is not being, again, goes back to measurement. Because if we had objective measures of performance, at first instance, then it's easier to see the basis on which you would move to the Court of Appeal, on which you would move from the Court of Appeal to the Supreme Court. But it seems once you're in as a High Court judge, it's now connections and where you are from that determines how you progress, which is regrettable. And these are some of the things also that contribute to the perception and lack of confidence. Lastly, but not the least, because I know Professor Utomi has strong views on all these issues. Prof, public trust doesn't depend on the bar and the bench alone. Society plays a central role in shaping expectations, in demanding accountability, and in supporting the value that underpin justice. And also, society contributes to the problem to the extent that we're in a society where, be it in business, be it in politics, people want to win at all costs. So they will also do whatever they can to subvert the system, either by their choice of counsel or by their willingness to approach the judex. So having listened to all this, what behaviors, civic habits, and cultural expectations must be strengthened for Nigeria to build a justice system that earns and keeps the trust of its people?
Well, thank you so very much. I'd like to begin by saying that central to my interest in this process is that my academic work is in the area of institutions and economic performance. And I think sometimes lawyers don't realize how important the role that they play, the role of the judiciary, the rule of law, and property rights are central to all human progress. Let me begin. In 1998, I published a book titled Managing Uncertainty, Competition and Strategy in Emerging Economies. I wrote that book from out of Boston, sitting at the Harvard Business School. And I came to Washington. I interviewed people from the Corporate Council on Africa and all of that. A great majority of people who will not, at that time, invest in Nigeria would not do that because they were not certain of outcomes of disputes. Because I said to you, the easiest thing in Nigeria is for the guilty party to go to court. And they know they will tie you up forever. And so you lose, whichever way you look at it. And so impressing the point of the importance of the perception that the justice system works in Nigeria is critical, has been very central to the passion of my activism, if you want. And very often I give examples. I make a point, for example, that in the United States of America, due credit is given for why it is a very entrepreneurial country to the role that the judiciary has played. Not even Ministry of the Department of Commerce and all of that. Indeed, a couple of years ago, two University of Chicago professors, Raghuram Rajan and Luigi Zingales, wrote this book, Saving Capitalism from the Capitalists. And they made a very interesting point about a justice of the Supreme Court, Louis Brandeis, who I think was the very first Jew to sit on the Supreme Court. And the series of, if you want to call them, activist judgments that Brandeis pursued is the reason why America is where it is easiest to start a business and overtake dominant business classes. So if we don't build a judiciary that is sensitive to that, and I see judgments many times, not being a lawyer, that shock me because they go off the course of common sense. And this is where the perception thing comes. Ordinary people have sense, they're not stupid. And if judgment, driven majorly, I guess, by technicalities, do not look like they align with common sense, whether it is true or false that there is corruption, the perception comes in. And let's talk about perception. It's much more important than reality. You know, if there's a football match on a Saturday evening, it's amazing that the people buy the newspaper on Sunday morning to read about that match are the people who were at the stadium, not those who were not there, because they're looking for a reinforcement of what they saw. Cognitive dissonance, this whole dissonance reduction business. Now, let me just skip a lot I could say around that, but come to the biggest problem the Nigerian judiciary has now come to face. That is judgments around politics. They have damaged the judiciary a lot. I mean, the first thing you hear people tell you around the world, as I seem to wander around it quite a bit, is your country is a very strange place. You have an election, and you have a person who came out the winner, second place, third place, and somehow your judiciary manages to give it to the fourth place. How do you guys manage your logic? It doesn't matter what technicalities you play at, because it's so against common sense. With the judiciary, travels very far. Now, to deal with it, which is we're looking for solutions, we have to be very intentional, very, very deliberate. It wouldn't just happen, because these perceptions, once they take root, stay. I think that one of the things we must do is prevent the judiciary from deciding on politics. Okay? If disputes have to go to a court, judiciary must not say he won, she won. Okay, this didn't follow the process, go back and do it again. But when this judiciary makes those kinds of decisions, it creates a public perception that this is not about the good of the system, especially since legitimacy in a democracy flows from the electoral process. Once that process loses the trust factor, well, it's judges who determine elections, not, then we have a huge problem. We've got to find ways of not allowing these political kinds of things end up being the outcome of court judgments. But whatever ways we get the political process to be responsible for the outcomes rather than the judiciary is important for the system. And if they ever have to be the outcome of what the judiciary does, it must be, this is the process, you didn't follow it, go back and get it done. That would save the judiciary a lot of reputation issues. But lawyers not, again, I've had dilemmas. I've seen very important lawyers tear down the judiciary. My dilemma is, there's the duty to expose wrongs so that we can fix. There is the problem down the judiciary, so what do you expect? These are lawyers doing it. Why should we think differently? It's actually really much worse. So there has to be a mechanism for the bar to be involved in a process that allows these things to be sorted without lawyers going around everywhere just tearing down the judiciary. Because all of us pay a very, very dear price for that happening. No, the judiciary used to be such an elevated. Look, in this very building here, I used to remember spending time chatting with Sir Danley Alexander, Supreme Court Chief Justice. He drives himself up here in his Igala. I used to joke about Volkswagen Igala. But you couldn't touch his reputation. People knew who he was. We must go back to elevating judges to that. Where they are almost holy grail. as they walk around. We have allowed the system to devalue the judiciary. It is not good for all of us.
Absolutely.
It must not be allowed to continue. So we have to find ways of communicating that something is being done, that we're getting things done right, and that, this is, I had the privilege of writing a PhD thesis, talking with General Gowon about all kinds of things. I spent the weekend, he was on exile then, back in the UK, 1981 or thereabouts. And we got around to talking about Chief Justice Elias. And he had all kinds of jokes. And he said, look, Justice Elias, he was gray, he was the oldest, they were young. Was quite gray. And when he's running very late, he will rub polish on his hair. And when the argument gets really, really, he will start dripping. But one thing you will be sure is that he stood for right. That this must be where we get back to if our country is going to make progress.
Thank you so much, Prof. Thank you so much. And you know what? Your comments take me back to Professor Oshibajo's comments in his keynote about the fact that the judiciary cannot fix itself, and that we would need all stakeholders, especially the executive, to acknowledge the fact that there is a problem that needs solving, and to resolve it in such a way that doesn't impinge on judicial independence, because it's a double-edged sword. But this requires, wholesale reform. It's not, and that's also clear from the results of the survey. This is not something that we can deal with now by tinkering with one aspect of the issue. Because like from what you've just said, it's really not just about appointments, it's not just about funding, it's about a wholesale retooling, complete retooling of the system. And we have to do it. We have to do it. Well, that is it in terms of our panelists. Now we're going to take questions from the floor. We cannot, because we're so far. I think that's what Shola is about to tell me. That is fine. No. Yeah. No, the Q&A is not, we're not going to take, or regrettably, we can't take too many questions because we really are against, time is against us now. So I think we'll just take 3 questions. Perhaps we won't even have, 2 from the room and 1 online. And maybe we'll find that the speakers have been so eloquent that there actually aren't any questions. But if there are questions, please indicate. We're going to take 2 from the floor and 1 from our virtual audience. I'm not going to pick somebody from SP Ajibade and Co. You're not a guest. So Ahmad, put your hand down. Yes. Mr. Akioshu, SAN. Yes, and for gender balance, yes, the lady, oh, yes, Miss Adamoleko. Yes, I'm very happy to hear from her. So, Dapo, please, you first. Please tell us, microphone.
Thank you very much, and may I join all who have congratulated you for this good work you have done in putting this session together. My name is Dapo Akioshun, and I'm not sure whether it's a question or comment, but when you were talking about judges feeling personally attacked, I saw Justice Abiru cringing a few times when the comments came, and he said some of those things. I'm sure he has been agitating about them as well. But my comment comes more on the issue of how to deal with many of these malpractice issues. We often say judges do what is wrong, but there are lawyers who take these applications before the judge. A judge will not just give a ruling or judgment in vacuum. What is the NBA doing about sanctioning lawyers who take these applications to the court? And I think that is one area where we need to be a bit more disciplined and serious. I remember there was a case we were doing, and I was trying to file the case in Ireland. We were trying to get an injunction to stop a letter of credit being paid. We had gotten the order in Lagos. The bank in Ireland told us, we will not obey a Nigerian court order. We will not. So we rushed to Ireland trying to get the same order from an Irish court before the bank paid. They had told us January 9 we will pay because they have fulfilled all the conditions. But the first lawyer we approached, we were looking for lawyers to help us file in Ireland. A lawyer that accepted the brief, he was going to take the money, then said, well, what is the matter about? And we said, stopping a letter of credit. He said, no, I cannot file that action, that I will not take that brief, that my bar will discipline me if I'm found to have done to file this action. Eventually, we got a Nigerian-based, a Nigerian origin lawyer who understood our urgency to take the case. But it just showed me that if lawyers know that they will be sanctioned for taking that application, then I think we'll be a lot more disciplined. Thank you.
Thank you very much, Tapo. Thank you very much. Just on the point of what is the bar doing, again, I cannot help but refer to my good friend and brother Olumide Akpata as president of the NBA. He referred a matter to the NBA Judiciary Committee when I was chair. When there were political judgments, where you had, I think it was an order of a high court in Rivers State, which was then countermanded by the judgment of a high court in Taraba and another judge in Jigawa. And we carried out extensive, in fairness, the NJC on that one called the judges were sanctioned, at least they were queried. We did the same for the lawyers involved. They took us to court. I mean, I think probably the case is still in court. They sued myself, Shehu Abimbola, the panel of that the Judiciary Committee set up, and the matter again got tied up in the court system. So it just shows you that we're not serious. Even when the system tries to cleanse itself, the same system fights back. Because that was an attempt to say, you can't do this. How could you have argued you went to a court, you were refused an order, and then you went to another court and got that court, knowing very well that you had been refused an order or that an order had been granted, to grant a contrary order. It's a complete nonsense. And as Professor Otome has said, it's like we don't realize the importance of our role to society, to having an organized, civilized society. And lawyers are doing this day in, day out. And judges are allowing them. So between the two sides, no, not you, my lord. Some of your colleagues. Mr. Damoleku.
Thank you. Good afternoon, everyone. So let me say I represent, so I'm not a lawyer. And so when you said the point that to fix the judiciary, you need all stakeholders. So as we give, maybe if people are still speaking, what would role for citizens? When we teach about the three arms of government, we talk about the executive, that you can vote them in and out, technically. We talk about legislature, that you can recall them again, technically. But for the judiciary, that you actually have no role. As a citizen, you don't vote them in, you can't, there are seemingly no mechanisms that citizens can hold the judiciary accountable. So how can we be part of the cleaning up of the judiciary? Thank you.
Chef, Ms. Adamoleku represents civil society. She's the convener of Enough is Enough, a civil society organization.
Doc, before we, the former president would like to make anything, then we can take all the...
Okay.
I think my lord wants to respond to that particular...
Okay. Mr. Adamoleku, thank you for that question. We spoke about monitoring, in terms of monitoring what judiciary does. There are basic things that we are supposed to do. Judges should sit in court by 9. They should, there are basic things. You might need to train some of your monitors, some of your people on these basic things. Just report. Just reporting. Because no judge wants the name in print as having not done the basic things they should do. So if a judge knows that I'm going to be reported to be sitting at 11 every day, when I'm supposed to sit at 9.
Or not sitting at all, sir.
Or not sitting at all. Or when you sit, your attitude in court is very unproductive. they will serve as things for them to know that, look, we need to be held accountable. Many of us are not, unfortunately. We behave as if we are doing a favor to society by sitting. It shouldn't be. So that must be pointed out so that we can reposition ourselves in terms of how we approach our work. So that will help tremendously.
Thank you so much, my Lord. I mean, and just to add, and just to reinforce what Honorable Justice Abiru has said, the court monitoring system that the NBA sought to put in place was going to be in conjunction with, as a matter of fact, we signed an agreement with one of your sister organizations called Partners West Africa, because we knew that we would need civil society involvement to monitor the court so that we would achieve this result. Let everybody sit up. And it wasn't just to monitor the judges, it was also to monitor the lawyers who were bringing the funny applications, and the registrars, lawyers who would come to court clearly with no plan to progress a matter, just to stall proceedings. That the reports should go back to the LPDC, to the MBA, reports on the judges should go back to the NJC. We're still on it, we haven't given up. Osaro and I and the Justice Reform Project and our newly minted secretary, we're still working at it, we're not giving up. Because I keep saying that if we give up on this, then we might as well, if I had gone to learn carpentry in 1988, I'll be making some really good chairs by now. So having not gone for carpentry, this law, we have to fix it. Do we have any questions? Do we have any questions online? No, we wanted to take at least one of our virtual. Yes. So to Justice Abiru, what is the attitude of your brother justices to streamlining or limiting the jurisdiction of the Supreme Court to strictly matters of constitution and dispute between the state and the federal government? Will the situation where all the states of the Federation have their Supreme Court on mainly state-related matters, land chieftaincy, etc., be supported by the justices of the Supreme Court if proposed? Now, before you answer, my Lord, it goes to the point we made about the executive, because obviously, if the law changes, if the Constitution changes, the Supreme Court you'd have no choice but to implement the law. So I guess the question is saying, would you be happy if the law were to change in this manner?
Look, honestly, we will be excited. Because it is the work we do at the Supreme Court is backbreaking. We are bogged down with matters. In fact, was it 2 days ago, I had to ask a lawyer. The matter I brought to the Supreme Court was a matter about ranking, which should be number 2 to the Oba of one village in somewhere in Ekiti. And it was like, what is our business with this? Whether you're number 2 or number 1 or number 3 to the Oba, how does that concern? But that is what is happening. Proposals have been made. We're hoping that in the constitutional amendment, something will be done. We said that matters of matrimonial causes, chieftaincy matters, tenancy matters, have no business going beyond even the High Court. Because husband and wife divorce matters, what have come to the Supreme Court? Chieftaincy, you should be a chief of a village. The High Court that understands the custom has given a judgment. You're coming to people who don't understand the custom. So these are things that, if it is done, honestly, we want it done. We have proposed it. But it's a constitutional issue. Until it is done, we have to keep on doing what we are doing. So hopefully, we hope that there will be amendments done. Even the issue of elections that we also spoke about. We said that matters of pre-elections have no business coming to court. The parties should choose their candidate and run with it.
And have their own internal mechanisms for sorting out their disputes. Yes.
So
yes. Thank you, my Lord. Mr. Kwata.
Thank you, Dr. Ajibade, and thank you to the panel. I thought it necessary to speak on 2 issues. As Tunde has alluded to, I've joined him in the trenches on this matter. He is not giving up, but for me and some of us, we're jaded. were a bit tired because the report or the excerpt from the survey that you read out spells it out as it is. We have a crisis on our hands. The system is broken. His Excellency Prof spoke to the point that no reform can be driven or led without the executive being fully involved. We're all in agreement on that point. When I was president, we kept the executive would need to lead the charge. However, the executive is peopled mainly by the political class, who are beneficiaries of the broken system, who depend on that system to remain broken so that they can achieve their aims. So we have a problem. It is a catch-22 situation. They are going to be, at best, clay-footed in their approach to reform. Of course, you're going to keep the judge impoverished. Of course, you're going to keep so that the judge will find a way to come to you. Of course, you're going to keep the system starved of funds. And so that you, Mr. Governor, will say, I bought Prados for my judges. That's the plan. It is. They're not stupid. They know exactly what they're doing. So we will need some external stimuli. Maybe Donald Trump. or
to invade the courts.
Or Yemi, my sister is here. Just as we had end SARS, end bad government, we might need end bad judiciary. Because it's looking like if those who ought to lead the charge are not ready. They're not ready. And as HEVP was speaking, he listed the problems, as you said, today we know them. Appointment, the process of appointment. Your Excellency, as you would recall, I was aghast when I attended my first NJC meeting to look into the appointment of Court of Appeal justices, where we spent more time than you will spend, less time than you will spend interviewing your Megad to interview would-be Court of Appeal justices. Yes, we spent less time. And then the general consensus was, oh, they've done well, let them go. And I said, my Lord, done well. Somebody was asked in this room, what is the principle, what is stare decisis? He didn't know. You want to send him to Court of Appeal? Mr. President, you don't understand. I said, Court of Appeal said they will learn on the job. I quote, direct quote. So they are not quite ready. So I think we need to rethink our approach to the issue of reform and how to bring it about, because we're backing up the wrong tree if we think that those who are benefiting from this broken system would, for 1 minute, help to fix it. It's not going to happen today. And then, second point I wanted to make, my Lord Josabiru, on the issue of the judges. I find out that the judges and the justices, at least when I was president of the bar, there was pushback because, as we have alluded to here, any attempt to criticize the system is taken by most of the judges as a personal attack. Madam President of the Court of Appeal barely speaks to me till today. Because when I called out the system of appointing Court of Appeal justices, I don't know, for some reason, and if you read her response, it seemed as if she thought that the NBA was attacking the Court of Appeal, which was far from. We were trying to help a situation because some Court of Appeal justices quietly complained to us that we are doing the work of 3 people because some of the people they bring to us here don't cut it, they don't pass muster. So we thought we were helping, but apparently we were not. And in closing, my Lord, perception is reality. point you raised about the singing of on your mandate. We're not blind, my Lord. A lot of us saw that the judges were not singing. But the question, and this I'm speaking to the issue of perception, the question many of us asked ourselves was, how can it be, or how could it be that at a conference organized for judges by judges, that tune was aired? And some of us now said, hopefully the NJI or the organizers will come out and quickly issue a disclaimer, which the NJI did, thankfully. But I think Madam CJN ought to even take a step further and ask the administrator of the NJI how come that happened, because it was embarrassing to the judiciary. And tomorrow, a year from now, 2 years from now, when the argument is being made that we have a subservient judiciary, it will be tendered as evidence. Nobody is going to jump at that point in time to say, oh, we didn't sing. It will be, how come this happened? I later heard, we were later told that the president came along with the brigade brass band. I think, maybe we should make sure that that doesn't happen again. That should not happen again, because it is a separate arm of government. It's a conference. If it was a conference at the State House Banquet Hall, fine. But this was a conference at the NJI organized for the entire judiciary. Bad optics. So I think my Lord should, also know that we are trying to protect what is our institution. I thank you.
Thank you very much, Mr. Akwata. I think on the first point, those were interventions, not necessarily questions. But on that first point, I plead with all of us. You say, I haven't, yes, we can't give up, Olu. We can't give up. If we give up, then let's move to another country. For as long as we're here and we're Nigerians, we can't, no. Okay, no, we won't give up. And I believe that, events such as this, advocacy such as this, because, those who, I agree with you entirely. Turkeys don't vote for Christmas. Those that are benefiting from the dysfunction in the system, they know what they're doing. And they would rather nobody spoke about it. They would rather just continue doing what they're doing and getting away with it. The fact that, channels are here. Everybody is, the more we talk about this, the more uncomfortable we're going to make those people be. The more we say that there are actually solutions, we're just waiting, can we please do something? Hopefully, with continued agitation, we will get results by God's grace. Okay, no more questions. I know that lunch is way overdue. We've overshot our schedule, but we also have a competition that we run. What do we want to do next, Shola?
Presentation to our
Okay.
panelists.
Is that before we do the...
Yes, and then, yes.
Okay. Yes.
And the photographs, and then we'll do the...
Okay.
The gifts.
Well, I'll hand over to... Are you going to handle this?
Doc, please go ahead.
Well, we're just going to do this all at once. Your Excellency, our distinguished panelists, we have these little tokens of our appreciation for your contribution to this event. We're really, really grateful. I thought, given the time that has expended already, we would not do any formal presentations. We'll just deliver them to you. We thank you so much. You have one for me too? Okay, we also have a tradition at our annual business luncheons. We run an essay competition, and I'll now invite the chair of the judging committee to come and deal with the presentation. Mrs. Abietam George.
Good afternoon. I think that we have benefited a lot from what has been said already. Please permit me to rest on the already well-established protocol. And we thank everyone immensely for what has been done here today. I am one of the judges that looked at the submissions by our young lawyers. And I must tell you, the process is fair, is accountable, and indeed, it was rigorous. Each of the submissions were examined on a scale of different metrics. We looked at conformity to the guidelines that were given to them. We looked at clarity of thoughts. We looked at even spelling of their submissions. We looked at originality. We looked at depth of their contributions. We looked at relevance. And indeed, we also looked at their reaction to the topic. Now, all of the conversations here and interventions were reflected on those scripts. When I mean reflected, and even more. I think we agree on so many things. But one thing that I discovered in reading those scripts that we haven't emphasized at all is about these young minds, these young lawyers, the emotional, the psychological damage it has had on them. And I'll give a very disturbing example that was written. A young lawyer went with a senior partner to the police station. And the senior partner told the young lawyer, please do not introduce yourself as a lawyer. I want us to deeply reflect on that. Now, all through the scripts, you could find such very pathetic and disturbing interventions. And so, the judges did their work, and it was submitted to another team to assess and come up with the winners. So in essence, it was a very fair, transparent, and accountable, rigorous process that was taken for the winners to emerge. Without much ado, I'd like to hand over to our very respected former Vice President to announce the winners. Thank you so much.
Thank you very much. So we'll just go to the announcement of the results. We start from the third position. Third position, Mr. Victor Ogunjobi. Victor Ogunjobi. Okay. The second position, Benedicta Ajay. And the first position, Israel Egbekunle.
Thank you so much, Prof. I think with that, it's just a group photograph and then lunch. I think we're all very hungry now.
So we'll first take this one of all our speakers, and then the partners of SPA Ajibade and Co will join them for another photograph. Partners, please quickly. Let's do this quickly. So we'll ask the partners to excuse us. Please, can I just have the former president of the bar join the speakers? And then, partners, please excuse us. Let's have the former president, and then that will be it for the photographs. Thank you. Just one more, sir. Just one more, Prof. We just want the former president of the bar to join the pictures. Okay. Leonard Silk. Thank you. And so after these photographs, we'll have our speakers proceed to lunch first, and then we'll make the order as to how the other tables will join the lunch. So please, let's have our speakers proceed to lunch first, and then we'll have the staff of SPA Ajibade follow, and then we'll make the... Yes. Can I have a member of staff just lead our speakers straight to lunch?
have been having this discussion on our own, but you have taken time out to be here, not only to attend, but also in order to be able to take Nigeria's judiciary to the next level. And we hope to see you again at the 19th edition of our annual business luncheon.